We are covering the closing arguments and verdict in a three-defendant attempted murders and home invasions trial in Tallahassee, Florida. One of the three men standing trial, John Darius Wright, is accused of shooting rookie Tallahassee police officer Caleb Babb while they were running from a home invasion scene on Sandpiper Court in Tallahassee in September of 2023. Officer Babb suffered a massive loss of blood as a result, but thankfully, he survived and is back on the force. He testified on the first day of trial, and he and his family were back in the courtroom to watch today's closing argument and hear the verdict. This case involves two home invasion robberies. The first was allegedly committed by Wright alone, and in that robbery, he ended up shooting a member of the Patel family in the face, but that victim also survived. The two other defendants, Raheem and Tyrell, Guinea, were allegedly part of a second home invasion that occurred a few hours after that, with Wright allegedly also being involved in that one. Prosecutors argued Wright shot a member of the Patel family and then invaded another home, aided by Sanders and Guinea. In that second incident, the rookie police officer, Caleb Babb, was shot in the leg when he responded to the scene. All right, here are the closing arguments by prosecutor Georgia Kappelman.
Very serious.
Jury. See if we can keep you awake for this final part. All right. Okay, so closing argument. To explain to you what the evidence has shown, hopefully make it make sense, and really the chance to argue to you what the points are that we want to make. So the evidence has shown that on September 25th, 2023, these three men were responsible for a violent string of events. Who are the three men? Oh, clicker works. Three men who think they can kick down doors, take what they want, shoot anyone in their way, and lie their way out of a situation, whatever the cost to others. Men who think they can come in here and sell you something other than the truth. They met up at the Baymont on North Monroe, where a room was being rented by Mario Shavers, a man who had at least some connection to the Sandpiper victim, Mr. Harris. Why they targeted the Patel residence is still a mystery. And I warned you at jury selection, you're not going to get the answers to everything. And this is one of the big question marks in the case. Why did they go to the Patel residence? Perhaps the defendants thought that since this family owned the convenience store, they might keep large amounts of cash in their home. And the evidence has indicated that cash is what the defendants were after that night. Wright and Guinea arrive at the Baymont in Wright's Corolla at 9:47 p.m. as evidenced by the surveillance there at the Baymont and Guinea's phone records. So the car arrives at a time, and we can put Guinea with the car, arriving at the same time that the car does. Well, what were they up to that night? Well, Guinea says just 2 hours before the crime that he's trying to put some money together. How were they going to get money? Were they going to sell drugs, as Guinea's lawyer has suggested to you? Is there evidence of that? She says her client is a drug dealer, and maybe that's true. But it is to the evidence alone that you must look to make your factual determinations in this case. Now, there were drugs at the Sandpiper residence that they tried to steal. So maybe he was going to sell those drugs to get the cheese, to put some money together. But other than that, there is no evidence Guinea was selling drugs on the night in question. Montrell Harris's phone was reviewed by law enforcement. There was no evidence of a drug deal planned with these guys that night. There is no evidence of a drug deal planned between Montrell Harris and anybody that night. The evidence is to the contrary, and the witnesses both said they weren't expecting anyone that night. There is a connection through the phones previously between Shavers and Harris. So maybe Shavers identified Harris as a potential target for a burglary. a home invasion. They certainly were not selling drugs or stealing drugs at the Patel residence. And by the way, Mr. Guinnea's own statement is totally contradictory to the defense that is now being put forward on his behalf. Mr. Guinea says that he was in Orlando when these crimes were committed. Just a reminder to be on the lookout in deliberations for discussions about things that are not in evidence. And this is going to happen in every trial, but I'm especially worried about it in this one because there's so much. So many rabbit trails to potentially go down. And you must not let speculative, imaginary, or forced doubt influence your verdict. A pretty good rule of thumb is that if you are back there and you're having a discussion about something that no witness and no lawyer ever talked about, that's probably speculative, okay? So be on the lookout for it and somebody rein it in. Even if it's something that one of the lawyers said, what we say is not evidence. It has to be from the evidence that was introduced or the law that the judge has given you. Let's see. Okay, I think I am trying to be here. So Wright and Guinea are already at the Baymont when Mr. Sanders arrives, and that's what this slide represents. Sanders arrives at 10:55. His lawyer told you that the evidence would show that he just wanted to buy weed. Now Guinea's lawyer is saying he just wanted to sell weed. So why did they even need to leave the Baymont? Why didn't Sanders just buy the weed from Guinea when they were sitting in the car together right here at the Baymont? Again, defendant Sanders' own statement conflicts with the defense that he's putting forward. He wasn't trying to buy weed, right? He was home with the kids. So they don't do a drug deal in the Corolla. Instead, the three leave together in the vehicle, and this happens just a few minutes after Sanders arrives. Three are together in this car pulling out. Where do they go? They go back and forth a couple times to a storage unit. They're communicating with Shavers during this time before they go to the first scene. Why? Well, we don't know. All we know is the plan is to get some money. Guinea indicates here at 11:52 that he's trying to get some cheese, which we know means money. This is less than an hour before the first crime. How and where were they going to get the cheese? Their first target is Cypress Point. They arrive at 12:40 in Wright's Corolla. They've been together now nearly 2 hours since the beginning of this whole Baymont episode. We know Wright was here at this scene because he entered the residence and he was identified by one of the victims, Mukesh Kumar Patel. There's the car arriving. Here is the corroboration that Guinea was there. His handset arrives at the same time that the car arrives. Guinea was in a somewhat heated text conversation just prior and shortly after his arrival at the previous slide. I shouldn't have gone forward. Just before he gets there to Cypress Point, he's in this sort of heated discussion with his girlfriend T. What are you doing? You're talking to this guy, whatever. And they're back and forth, a discussion that he abruptly ends when the crime is committed. And he doesn't engage or respond to her at all after that, until after the Sandpiper crime. And even then, he doesn't pick up on the discussion about this guy or whatever. Then he's in, help mode. All right, so let's talk about the shoe. Did y'all notice, I should have had it in my slideshow, but I didn't get it in there, that the shoes that Mr. Wright is wearing in that first Baymont video in the hallway, so this is before the crimes, are these shoes. You can see him on his feet in the hallway. When you see him in the hallway again, right before he gets arrested, so after the crimes, remember when the cops come and pin his vehicle, he's not wearing these, of course, because he's lost them. He's wearing the slides. These shoes first come into play in that first Baymont video, but then of course they come into play again at Cypress Point, because this shoe kicked in the door at Cypress Point. Size 12 Jordan. Left a mark behind, unique to this size, pattern, and design of shoe. And then Wright enters Mr. Patel's room, stands over him with this .40 caliber pistol and shoots him in the face, where he sleeps in his bed. Because the gunshot and not the alarm was what woke up the Patels, we know that he went basically straight from kicking in the door right to Patel's room and shot him, because there's that period of time where it's just beeping, but it's not, the alarm has not deployed yet. So we know he went straight in there and shot Patel because the dad, Patel, was not awakened by the alarm. He was awakened by the gunshot. Why did they do it? Again, sometimes crimes are just senseless, and that's why the law doesn't require us to prove the why. We don't always know why people commit violent crimes. Yes, we know these guys were trying to put money together, but they don't even ask for money from the Patels. He didn't take anything. Maybe the plan was to steal, but he got spooked by the burglar alarm. Maybe he realized there wasn't time to try to control all the people in the residence when that burglar alarm was about to go off and the police were going to be notified. Maybe he aborted the plan for some other reason. We do not know. But for whatever reason, he left without demanding or taking anything. And that is why the count 1 is charged the way it is. Remember in jury selection, we talked about attempted first-degree murder and how it can be proven in 2 different ways. So you can have the premeditated first-degree murder or the felony in the course of committing a felony first-degree murder. And for the crimes against the Patels, it's charged as attempted premeditated murder. So how do we know that Wright intended the death of the Mr. Patels? So he's charged with 2 counts, one for Panal Patel and one for Mukesh Kumar Patel. And the intent, of course, is an operation of the mind. How can you ever prove somebody's intent? The answer is, in this case, pretty simple, by their actions. What do the actions tell us about the intent of the person? And what better evidence than Wright entering this man's home in the middle of the night and shooting him in close range in a place where he was supposed to be the safest, right? Our bed. He did so without a word, and he left. How could Wright more clearly demonstrate to Patel and to you that his intent was to kill him? Shot him in the face, not in the leg. What better evidence could there be unless he completed the act, which was avoided only by the grace of God? I don't know what happened to my slides here. I should give up on slides because I'm terrible at it. Carlys, there he is. The same analysis applies to Mukesh Kumar Patel. When he encountered Wright, Wright fired 5 shots at him from just across the room. 5 shots. Magically didn't hit him. They all went into this door and around this door right here. Again, it's only through divine intervention or luck that the murder of the dad, Mr. Patel, did not happen. 5 shots? That's why Wright is charged in count 2 with attempted first-degree murder for shooting at the dad, Mr. Patel. His actions show that when he entered that residence, he formed a conscious intent. It's not a certain amount of time that you have to plan it, but at some point, he made a decision to kill. And it was before he shot the younger Patel, right? He was willing to kill those people in that residence, and his conduct thoroughly demonstrates that. Count 3 is a burglary for entering the home while armed with the intent to commit some crime inside and for assaulting the Patels while they were in there, while he was in their home. In opening statements, Wright's attorney told you that all the evidence against Wright would be circumstantial. And we learned in jury selection that circumstantial evidence can be very good. It can be more compelling than direct evidence. But that isn't what the evidence has shown, is it? We didn't have just circumstantial evidence. Do you recall the testimony of Mukesh Kumar Patel? Although the man who shot his son and shot at him was wearing a mask, which to him looked like a Spider-Man or a Superman design, he did not know Mr. Wright, but when Mukesh Kumar saw the eyes of the man who shot at him, he recognized him. Different from knowing somebody. Recognized him. He knew those eyes, and he was able to identify him here in court. Hence, Wright and Wright alone is charged with the burglary and the attempted murders that happened at the Patel residence. And you may wonder, well, why isn't Guinea charged? We talked about principles and, what needs to be shown for a person to be held accountable for the things that their co-defendants did. We intuitively know, and the law also agrees, that simply being at a crime scene is not enough, right? You have to know what was going to happen, or at least have a conscious intent that a crime be committed, and you're a part of that. Now, we talked about how if your co-defendant kills someone in the process, sometimes you can be held accountable for that too, but you have to know there's going to be a crime committed and be a part of that plan. You can't just be along for the ride. Okay? So how do we know whether Guinea was along for the ride or whether he was a part of this plan? And we're talking about Cypress Point, okay? What did he do? What do we know? Well, we knew he was trying to get the cheese. But the answer, I think, is probably he knew the plan. Probably he was already the getaway driver at Cypress Point. But probably doesn't cut it in criminal court, right? We know that. So if we give him the benefit of the doubt and we don't charge him as a principal to Cypress Point, we see what he does next. Because if he's not a part of the plan and he didn't want to be a part of robberies and burglaries and attempted murders, what's he going to do? He's going to go home. He's going to separate himself from these guys, right? But that's not what he does. Instead, he continues along with them. He makes a choice that proves he is a part of this plan, okay? And that's where the turning point is for Mr. Guinea. He continues on to the next burglary scene. And the judge has read you the accessory instruction. So this choice to continue on with the plan is the evidence coupled with his stated motives to get cheese and put money together that night that makes him responsible as an accessory to what happened at Cypress. If he just goes home right from Cypress, he's not an accessory. But if he then demonstrates assistance to the guys that did Cypress, in this case Wright, if he does help Wright after to help him evade capture, which we're going to get to, but we know he does, then he can be charged and should be charged and held accountable as an accessory to those crimes. So I think the turning point for him is, he's probably in it from the beginning. But from our perspective, evaluating the evidence, he goes to the second one, right? And they went straight from the first one to the second one. They arrive at Sandpiper at 1:02 a.m. And this is why we did the accessory for that. For Guinea, and another part of the turning point is now that we've established his intent to be part of the plan, he's now going to be a principal to anything that happens next. Okay, following me? It's all about his intent. How can we prove for sure his intent? We're not really sure. He wanted to get the cheese and he was present, but how do we really know that he knew there was going to be a burglary at the Patels? We're not sure. But we know for sure when he went to Cypress. When he left Cypress and went to Sandpiper, he knew what he was in for, okay? All right, so what does Guinea do next? He spends an hour in the area of Sandpiper, an hour to consider and potentially renounce this plan if he didn't want to be a part of it. But he doesn't do that. What does he do to help or assist? Because he has to do something to help or assist, right? He's the getaway driver. We know that. He drove the car away from that scene and then spent hours looking for his co-defendants, trying to help them evade capture. So this is them spending time at the scene. This is, what does it say, 146? Shortly before the crime at Cypress. All right. What about these messages after? It's like he's going to war in these messages with T. He's not, oh, baby, I can't read them, but it's like, I'm sorry if this is too much for you, but I gotta go. I gotta go get my boys. I'm not coming home without them. I'm not coming home until I know they're safe. So for the crimes at Sandpiper, it's clear that he not only tried to help after the crime, but he also knew and endorsed the plan. He's helping them. He's looking for them. All right, so what about Mr. Sanders? What's the difference between Mr. Guinea and Mr. Sanders in reference to those first crimes? Well, Mr. Sanders told you in opening, it's because he wasn't there. We don't know if he was there or not, right? We know he was with them 20 minutes before the crime. We know he was with them after the crime because he's on video after the crime, and his phone is present after the crime, but we can't put him at Cypress Point. So the piece that's missing for Guinea, I think, is the knowledge, and the piece that's missing for Sanders is the physical presence. Physical presence isn't always required, but I think that's the main piece that's missing in the claims. Like, well, why didn't you charge Sanders with Cypress Point? Why didn't you charge Sanders as an accessory to Cypress Point? He certainly was part of the plan at Sandpiper, and we know that, and we're going to get to that. But I think that's the main difference between him and Guinea in reference to that accessory charge that Guinea has and he does not. All right, so let's see what's next. All right. This is more helping. Okay. Sanders at Cypress Point. Sorry, not Cypress Point, Sandpiper. All right, what do we know about Sandpiper? Sorry, my notes are chicken scratch. Just like Cypress Point, we know that the door was kicked in. That's what this slide represents. So it's sort of the same MO. Just like Cypress Point, at Sandpiper, the shooting begins immediately. They just kind of come in shooting. In this instance, though, the big difference is we've got two suspects entering as opposed to just the one. And the facts of entering are what support count 5, burglary of Sandpiper. So clearly in this one, we've got the motive of theft. They actually did demand things, take things, and that sort of thing. So that's why these attempted murders at this scene are charged as felony murders as opposed to the premeditated. With Mr. Patel, Wright goes in, shoots him, and leaves. Is it a felony murder? We don't know because we don't know what he intended to do. All we know is he shot him right in the face, which suggests he wanted to kill him. For the one at Sandpiper, we do know what they were doing in there, which was a drug rip, trying to get drugs, trying to get money, trying to steal things. So that's why that one is charged as attempted felony murder of Montrell Harris. The theory is the same theory, so that Montrell Harris, and then also for Officer Babb, it's in the commission of the felony or fleeing the violent felony, and during the course of that, the attempted murder takes place. So at Cypress Point, we have 2 burglars that enter. We know that shots are fired in there, one narrowly missing Montrell Harris's head, the one on the left that enters the wall there. That's the door casing on the right to his room where he peeked out and was fired upon. We know that Mr. Sanders entered this residence, whereas we only had one suspect at the first one. We've got Mr. Sanders this time, along with Mr. Wright, both armed with firearms. And you can recall the testimony of Ms. Oglesby, while Wright primarily dealt with her boyfriend, Mr. Harris, or I guess her non-boyfriend, Mr. Harris. Sanders primarily dealt with her. She didn't know Sanders. She couldn't identify Sanders, but from her position in the bathroom and then again in the bedroom once he brought her out of the bathroom and put her on the floor and put the gun in her face, she was able to see enough to give a basic description of him, which was thicker guy, black hoodie with something orange on the front, full beard. Wright and Sanders were in the process of taking what they wanted from Sandpiper and were on their way out in a hurry because remember, they saw that she was on the phone with 911. So they knew the law enforcement was on the way. And they encounter Officer Babb, who's in full police uniform. They already know cops are coming. And first Sanders is confronted. Babb gives Sanders lawful commands, which Sanders does not follow. Babb gives chase, and then we have that terrible moment when Wright emerges from the open doorway there and encounters Babb, and without hesitation, Wright fires at Babb, striking him in the right thigh. And there are still images of Mr. Wright during that encounter. On the stand, Officer Babb told you that his thigh immediately became tight and hot, and he realized he'd been hit. Wright is shot at by both Officer Babb and Officer Ryan, who at this time is coming around the corner and seeing the suspect flee. I think that's an image from his camera in the bottom right there. But magically, Wright is not hit by any of these bullets and is able to flee into that wooded area north of the incident location. There are still images from Sanders from the body-worn camera. And this is the slow-mo of Officer Babb's encounter with Wright. Pretty harrowing stuff. If you watch this enough, you can see the gun in his right hand. You can tell that the right shoe is missing. You can see the red bandana around his neck. And y'all will have this back there if you want to labor over it. You certainly can. Look at Officer Babb's leg when he looks down to try to apply a tourniquet and radios for help. Help arrives, and despite how incredibly close he came to losing his life out there, laying in the street, after being shot for what? A little bit of dope? Or a little bit of cheese for Mr. Guinea? Despite Wright's efforts to kill Officer Babb survives. Not only does he survive that night, but he survives 6 surgeries with a 7th still ahead of him. And he goes back to work. Look at his leg. He's so lucky to have that leg attached. Where do our bad guys go? We've got 3 different directions. 3 guys going in 3 different directions. Why do we care about what happened after the crimes? Well, because their conduct after the crimes helps us identify them and helps us prove what their consciousness of guilt is. That's a legal term, meaning like their intent, right? Are they going to go right to the police and say, hey, I was just waiting to buy a little weed and standing outside and something went down. Let me tell you what I heard and saw. or do they run and hide? So this slide is our montage of some of the Sanders images that we have. Where does he go when he leaves the crime scene? Well, so consciousness of guilt, what is it? What are some examples? I mean, generally people don't run and hide under people's cars when they've done nothing wrong. Troll on me, we learn, means the police are following me. Who was on him? Babb was on him. Why is he reporting that the police are chasing him if he did nothing wrong? Innocent people don't report to their friends that they're being chased by the police unless they were involved in a crime. People don't hide in a crime scene for 3 hours, avoiding detection and waiting to be extracted when they've done nothing wrong. What can we learn from defendant Guinea's behaviors after the crime? Does he have any of these consciousness of guilt indicators? We know that he left the crime scene in this Corolla. He drives the suspect vehicle away from the scene, an affirmative act in furtherance of the crimes. And I'm referring to all the crimes. He's helping them try to get away with all the crimes, including Cyprus. He is a principal to this crime that has just occurred, all these crimes that have just occurred. That's why he's charged in 5, 6, and 7 as a principal. He's trying to avoid capture. He's trying to help his co-defendants evade capture for all of these crimes, not just Cyprus, not just Sandpiper, all of them. We discussed in jury selection what a principal is, and the judge has read you the law on that. And that's the situation for Mr. Guinea in those counts. He wanted the crime to be done, and he helped. So he's on the hook for whatever happened in there and the reasonable consequences of whatever happened in there. So you remember my bad example at jury selection. If the court reporter and I go to do a inherently violent crime together, we both plan to hold up a liquor store, she's the getaway driver, and I go in to get the money, but something goes wrong and I shoot the clerk, we both get charged with first-degree murder because she intended to do an inherently violent crime with me. It had a natural consequence of someone getting hurt or killed. We're both on the hook, okay? So that's the Guinea situation for counts 5, 6, and 7. I want to bring your attention to a couple things in your jury instructions and verdict form. The bottom, okay, so for principal instruction, this is very confusing, and I'm sorry that we did this to you. But for count 5, Guinea, you're going to be asked interrogatories for Guinea. Did the evidence prove beyond a reasonable doubt that in the course of committing the burglary, Tyrell Guinea was armed with a firearm, a dangerous weapon? Check yes or no. There is no evidence that Tyrell Guinea actually possessed a firearm. And in the law, there's a difference between actually and personally possessed. Okay, so sometimes you'll be asked, did the person actually and personally possess? That means, did they have it in their hand? Other times, you'll be asked if it proved that during the burglary he was armed. If it doesn't say actually and personally possessed, he can be a principal to it, meaning he doesn't have to have it in his hand. It's just asking you if he was a principal to a crime and he or his co-defendants were armed. Okay? Super confusing, and I'm sorry. But if you look at the bottom of page 26, that last paragraph, this principal's instruction does not apply if the additional question asks whether the defendant personally and actually committed the act. That's saying principles apply unless, okay, so you can consider whether the person is a principal unless the question says personally and actually. Personally and actually is what triggers is it in his actual hand? Sorry. I did not, no one in this courtroom wrote the law, and we're sorry. Okay. one other thing. You've got this thick book of options, and these defendants have been charged specifically for the crimes the state feels can be and have now been proven to you beyond a reasonable doubt. On page 32 of your jury instructions, the second paragraph says, if you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. So you are required to convict for the highest offense that's been proven beyond a reasonable doubt. You have a lot of options because the law gives you a lot of options, but then it tells you convict for the highest offense that's been proven beyond a reasonable doubt. So if you go back there and you all get an agreement that attempted first-degree murder has been proven, you're done. You do not have to consider lesser included offenses. And if you do, I mean, you can. And if you do, you'll notice that they all fit because they're included. So if you've already decided this one's guilty of attempted first-degree murder, when you read down the list, you're going to be, oh yeah, guilty of that too, and that, and that, and that. And that's necessarily true because they're included. But just want to emphasize, I've only charged the highest offense that you're seeing on here, and that's what I'm asking you to convict of if you agree with me that the evidence has proved those things beyond a reasonable doubt. All right, we talked about how Guinea spent all this time driving around trying to pick these guys up. What is he doing or texting that shows any additional consciousness of guilt during that time frame? And I think I passed the slide, did a crummy job, but that's him driving around between 2:30 and 4:30 looking for his friends, his co-defendants. And then we've got him searching for the crime that he now expects you to believe he had nothing to do with. That's within an hour of the shooting. He's searching to see what's on the internet about this crime. Are we to believe he was just curious about the local crime report at 3:20 in the morning? What else? He dumps his phone. Well, he changes his phone number. He doesn't dump the device. Changes his phone number on the day of these crimes. Is that a coincidence? Was that just a part of his normal drug dealer routine? Do you have any evidence of that? He refers to himself as being in the clear. In the clear. Is that the terminology that an innocent person would use? He tells Alicia that he can't go home because of this case. Why not? Innocent people don't go into hiding. They don't have to leave the room to talk about news stories they had nothing to do with. All of this proves that Guinea had a consciousness of guilt. He was criminally responsible. And I want to conclude this with a summary of the evidence against Mr. Wright. No phone evidence. But other than that, pretty much everything on your wish list is here, right? Video, DNA, the weapon which fired the shots at both locations. Even the shoe prints are consistent. In closing, there can be no doubt about the harm done in this case. The victims in this case have endured a combined total of over 20 surgeries to try to repair the damage that was done. For what? There is only one verdict that does justice in this case, for them and for these three defendants, and that is a verdict of guilty as charged. Thank you.
Thank you, Ms. Kappelman. For Mr. Wright, Mr. Lammers, do you wish to be heard?
Yes, sir. Thank you. there if you want. Thank you. Good afternoon. And I'm sure on behalf of everybody here, wants to thank you again. I know you've always been getting thanked by everybody in the courtroom, but it is very important and it is sincere. Your being here is the only way to resolve this matter, and you've taken a full work week out of your life, plus whatever time that you can't talk with anybody in the evening and having to live your life differently in the evening in order to do your service on this jury. It's fantastic service. It's very much appreciated. I know everybody in here would say the same thing. And so thank you for being here and thank you for listening. Before I get into my closing remarks, I want to point out that even though all three defendants have been brought together and charged together, you have to consider the evidence against each of them individually, and you'll have to render verdicts individually. And that's because even though people are charged together, that doesn't necessarily mean that they are guilty together. It just means that they have been charged or accused together. Everybody is unique. Everybody is different. Their lives are different. They have different girlfriends, wives, whatever. And even if people may know each other, that doesn't mean they're joining each other in any kind of ventures. So I want you to understand that my purpose here is not to accuse anyone. That is the government's purpose, and that's perfectly proper. That is their role. My only purpose here is to defend Mr. Wright. I speak only for Mr. Wright. I don't speak for anybody else. I'm going to point out the evidence, but I want to make it clear that I'm not accusing anybody else. I'm not running around pointing fingers. I'm talking about the evidence of Mr. Wright, which I believe I'm very shortly going to be able to show you is unique and also justifies a not guilty verdict. So let me move on and start. What do we have? We have that evening, the Toyota Corolla leaves the Baymont Motel with people in it, heading up to that storage unit north of there. We've seen that. We have seen that the phone's track there shows that Mr. Guinea is there and he's contacting Mario Chavers, who is back at the Baymont Motel, where also Mr. Wright has apparently been checked in also. So Wright and Chavers both have been at the Baymont Motel. Chavers has not been charged, which just goes to show that association is not guilt, although I'm going to be talking to you and pointing out how I think the evidence shows he should have been. So when I said I'm not accusing anybody, I'm not accusing anybody here. It goes up there. Mr. Guinea is texting Chavers here. For some reason it was important for Mr. Chavers to know that Guinea and that they were up there at that storage unit for whatever reason. There's a texting to Chavers. I believe there were several texts. And then the vehicle comes back to the Baymont Motel. And at that point, the texts between Guinea and Chavers stop. And I think that is very significant. And the reason I believe that is very significant is it shows that Chavers was not in the car when it went to that storage unit, which had to be important for some reason for this night. And Chavers wanted to know what was going on up there. And as soon as they come back, it doesn't matter to him anymore. He is, we don't have any text with him anymore. Now we heard from Mr. Corbett that Mr. Chavers' phone was still in the room at Baymont, and that's one of the reasons they did not think that he was involved. I don't know if that is a proper conclusion to draw from that piece of evidence. Under that theory or that belief, it would be very easy for anyone to say, hey, I'm going to go commit a crime, hold my phone and keep it busy while I'm off doing it to make it look like I'm somewhere else. What we do know is Shavers is the only connection with Sandpiper, with Montreal Harris, with the drug dealing. That's the only connection, is Shavers. Now, counsel for the government correctly pointed out that maybe he clued them in, is what she said. I take it a step further. He's not just sitting back there in the motel room, kicked up, saying, hey, why don't you all go hit this place? No, he would be involved in it. I also want to point out that the identifications on the videos of who was who, the only person from that witness stand with personal knowledge or of supposed personal knowledge was Shadaria Cody. And she came on and said that she was in the driver's seat when the car pulled up. She had been arguing with Mr. Sanders when she got to the motel, that they had been arguing and fighting and fussing, and that she's sitting there and she's looking across and this guy comes back and now she says it was Mr. Wright, who she has seen only once before, supposedly at some place where she got her hair braided sometime before, which makes no sense. Why would Mr. Wright be hanging out where someone's getting their hair braided? Now, I'm going to have more. I'm going to tie that in to how bad that identification is, supposedly, of Mr. Wright. I'm going to tie that in with Mr. Patel also a little bit, in just a little bit. But I want you to think and consider that. She's getting up there, fussing and fighting. Get out of the car. Go. She's not looking at anybody else. And plus, she's sitting there and someone's standing above. She can't see who that is. And she's going to recognize a torso from someone she has only seen once before. No, that is not an identification. Mr. Corbett supposedly made some identifications, but if you remember, I asked him, we didn't investigate this. You have real personal knowledge. He said no. He just knows what people told him, what reports he read, and the records. And that's okay. That's his job. But any knowledge he has as to any identifications is second hand at best. He's not the one making identification. Somebody else did. Somebody else said that was Shavers. We don't know who in that video. But somebody told Mr. Corbett, who did not have the personal knowledge. There's no evidence of any personal knowledge. I think that's important too. I'm not accusing him of being dishonest, but it's just easy sometimes. He was completely honest about the situation, and of course he believes what he was told. But you kept hearing over and over again, don't read about this case, don't do this, because it's not fair. Because if you have something important to say, it should be coming here and be tested, and that the people who have been accused should have the right to contest it, the accuracy of identification. So I want to take these identifications out and look at what the real evidence is. I hope I haven't been too confusing at that point. I'm going to be looking down a lot at my notes. I have to read. I can't remember everything. I'm going to go through my notes, and there may be moments when I take a moment. So let's get moving on. They come back from Baymont. They've been up at that storage unit. And if Mr. Wright was driving the car there, which I don't concede, but if he had been, he no longer was, because Shavers is no longer, who was obviously involved in something here, is no longer texting. He's in the car. I want to make clear, he's in the car. So, and I think I will be able to prove that with the evidence later on. Car goes to Appleyard. He has no connection there. It's somebody's girlfriend, supposedly. It's not anyone who has a connection to Mr. Wright. And then the car goes out to Cypress Point. Why? Correct. Everyone said they had no dealings. Mr. Patel said no dealings that they knew with any of these three people. We don't know whether Mr. Shavers had any dealings out there. You heard how far out that is in the middle of nowhere. You have a Sunoco station, and then you have a residence across from the Sunoco station. Well, if you don't know these people, you're not just going to drive down there in the middle of the night and say, hey, here's a gas station. That maybe the owners live there. That must be the owners. We're going to go in there and steal some money. No. Somebody had a reason to go to Cypress Point. It wasn't Mr. Wright. No connection. And because there's a Sandpiper connection with Shavers, which is undeniable in the evidence, not even contested, obviously he's the connection to Cypress Point. Whoever it is goes in there. They also know where to go in the residence. This is someone who knew where they were going. When they kick in that door, they went right to young Mr. Patel's room and shot him. They knew. Somebody who has no connection with Patel isn't going to just make that guess. That's not a coincidence. That's someone who knew. That's not Mr. Wright. And now I want to talk about this great identification that you heard about. Let's talk about this. Mr. I want to, Mukesh Kumar Patel, I want to make sure I say the name correctly. I hope I did not mispronounce it. If I did, I mean no disrespect if I mispronounced it. I'll just call him Mr. Mukesh Kumar Patel, the father. From now on, I'll refer to him as the father to make sure I don't make a mistake. The father hears a shot, wakes up in the middle of the night. He's confused. At some point, the burglar alarm does go off. He does say the alarm was going off when he was looking at this person that was in there. I asked him that specifically. He said he only saw the gunman for at most 1 to 2 seconds. 1 to 2 seconds when you wake up in the middle of the night. He said it was dark. Burglar alarm's going off. You don't know what's going on. 1 to 2 seconds. He said he peeked around the corner and shots were immediately fired, so he went back into the room after this 1 to 2 seconds. You can imagine the confusion. You can imagine the fear, and you got a bare momentary view of someone. And he said, and this was his quote from on there, you remember, you can rely on your own memories, but he said he guessed it was a black man or black male by the way he shot. That's what he said on the witness stand. By the way he shot, he guessed it was a black man. And was disguised somehow like Spider-Man. He didn't see clearly enough to know it was a bandana. He thought it was a mask or something. He didn't know it was a bandana because he didn't get a clear enough view. In his mind, red, Spider-Man. Confabulation, not lying, trying to make sense of what you see in a confusing and frightening moment. It was a bandana, not a Spider-Man mask. It wasn't, and that's important because that shows how bad the view was that he saw. All he knows is he saw somebody shooting at him, a flash of red, and he went in there, immediately closed the door. It was seconds. If he had a good view, he would have known it was a bandana. Now, what do we also know? Besides saying he never encountered any of them before, sometime later, remember his son was just sleeping in his bed and got shot in his face. It's in the hospital. Going through, Lord knows, we heard what he went through, and I thought Mr. Patel, the son, testified with a lot of grace and dignity considering what he had to go through. Jaw wired shut, losing weight, having to go through surgeries, the pain, not able to open his mouth. You can imagine the effect of that on a father, who also might feel guilty for not having protected his son. I'm not saying he should have. I'm not saying he did anything wrong, but we can all understand how someone might have that emotion. And then here we are. The news, the papers, the TV news. You can go on your cell phone or your computer. All these pictures of the men who have been arrested. And it says what their role is. And now when he looks at that picture of who was arrested, he says he can tell by the eyes. Just the eyes. That he saw in that bare momentary view. We can understand his eagerness to avenge what happened to his son. But what we cannot understand or condone is taking that identification in any way, in any serious manner, particularly when so much is at stake in a trial like this. That is not any kind of identification. That is how wrongful convictions occur. So, as I said, Mr. Chambers picked locations, and that's also important why the bandana comes in. The only person who needed to be disguised is Mr. Shavers. He's the one who knew Harris, and I believe that the evidence has shown he's the one who knew the Patels through some way. There's no evidence that they were ever asked to look at Mr. Shavers or whatever, because his cell phone was going off, he was written off already. It also explains that when they get to Sandpiper, remember the text stopped once they got back to Baymont from the storage unit, then they go to Cypress Point, now they're at Sandpiper. Once they get to Sandpiper, door gets kicked in, someone goes in, Mr. Harris says someone shot at him, but we also see some other shot, just some blind shooting going on as soon as they come in. And that makes sense also. Shooters coming in, and it's blindly shooting, hoping that whoever else might be in there leaves, because they want to steal what's in there. Unlike what happened at the Patels, they did not try to shoot. Miss Oglesby, nobody tried to kill her. Mr. Harris was hiding, supposedly, it's not clear where, but he was hiding. He was not being hunted down to be murdered. The robbers were there on a mission to steal, and once again, they seemed to know where to go. They seemed to know the layout of that place, and only one person knew that. That's Shavers. They seemed to know where they were going. So, we hear those shots at Harris when supposedly when he was down there close to him. I don't think those shots, the evidence shows that they were really intended to kill him. I think they were intended to scare him, to get him to run away, to get him out of there so they could steal. They could go through and get what they wanted. That is my version, what I believe the evidence shows. And I also want to point out something else. You saw it from Ms. Cody, who had testified, and you heard about the difficulties they had trying to get her to come in here. And you saw Mr. Harris, when he was testifying, supposedly, not supposedly, a victim. That was not nice of me to say that. I apologize. But he was a victim, but you saw him. I don't remember. I don't know. You heard that in the community, or at least the community that Miss Cody and I would say Mr. Harris reside in, you don't get a reputation for cooperating with the police. Miss Cody admitted that. And you saw how reluctant she was. She wanted to say whatever she had to say to get off the stand and get out of this and just be done with it. And you saw Mr. Harris, who wanted nothing to do with this. It was obvious. And my cross-examination of him, I just wanted to show that he just couldn't remember anything that was of the most important part about what he saw of the people in the room or where he was. And he didn't want to cooperate. It's not funny, but it's understandable. It's sad, actually. But it also shows that Mr. Wright wasn't involved. And I'm going to talk to you some more about why the evidence shows that he wasn't involved. Talked about how the robbers seemed to know where they were going. Now, one of the big deals we're seeing here is the DNA evidence. And DNA evidence is, in the right circumstance, extremely compelling and very powerful, particularly when you have a single source. Talked about that with the DNA analyst, a single source. We're dealing with just one person's DNA. It's easy to make a comparison. But here we're dealing with mixtures. And that's good and bad. It's good because that means that the instruments are far more sensitive, and we now know they can get DNA from a lot of places. It's a lot easier to. The problem now isn't that there isn't enough DNA. The problem is there's too much DNA. That's really what the problem is now with the state of the science. And these are mixtures. The shirt had at least 3 contributors. I'm not certain what about the bandana had multiple. All these items had multiple contributors. And what that means is when they look in there, they see all these alleles in there, and then they take the standards, like from Mr. Wright, Mr. Guinea, Mr. Sanders, and they see, can we match those markers here? And either they're in or they're out. Okay, but there's still other people in there. And nobody else's DNA was ever compared in those mixtures other than these 3. So we don't really know who else was in those mixtures. It's a mixture. There's multiple people in there. And you also heard from the evidence that people can leave DNA lots of places. And some people leave more than others, just naturally. Maybe a good example is some people might have oily skin and some people don't have oily skin. We might know people like that. People differ. We're all unique. We're all individuals. Some people leave DNA very easily. Some people do not. So, what do we know? Okay, the shirt had 3 contributors. Mr. Wright was one of only one. The shoes had at least 2, of which he was the minor contributor, which they make a value judgment. And the bandana, I don't know if he was the major or whatever, but the point being, all they can do with that is say he's included in the mixture, and then they have this thing called the likelihood ratio. And it can be powerful in some ways. They say to try to give weight to the evidence. But what they do is we say, let's assume that they're in the mixture, and then we're going to assume that they're not. We have these 2 different conclusions. Now, statistically, which conclusion is more likely? That's all it means. It's more likely that he's in rather than out. It doesn't mean definitively that he's in. It just means it's more likely because it's not single source. But let's look at it this way. That's what the likelihood ratio is, and that's all they can say. It can only say DNA is present. It doesn't say when it got there or how it got there. And people who are in close association, their DNA can get spread out. Even in the laundry. You remember I asked, even in the laundry, washing clothes together, washing some clothes as it goes through and rinsed and everything, they can detect DNA from one family member getting onto another family member's clothes. You can see how that can create some problems in criminal cases when DNA is everywhere. And it's easy to spread and share. Driving in a car, sweating, September hot. Somebody in a shirt could be picking up DNA from someone else who's been in the car. Transference occurs. You heard them say that. It's real. That's not me just saying this. It's real. And I'm just pointing out how the DNA is not nearly as definitive as the government wants to say. They want to say his DNA's there, it's over. No, it's not. So, that's like we know that Shavers and Wright are at the Baymont. We know there's a connection between Guinea and Shavers through the text messages. I think you could assume a connection between Shavers and Wright or something. They're both at the Baymont. Easily how Mr. Wright's DNA could be on those items. A shirt or a bandana would be pretty easy to share DNA with if you were sitting somewhere where it was things, handling it back and forth. It's in the car. It would be really easy for DNA to get on there. But a shoe. Remember the testament, they swab from the inside. You're not going to swab the outside, you swab from the inside. A shoe is far more intimate item than a shirt or a bandana. It's far more intimate in many ways. The shoe. And what do we learn about the shoe? There was at least one other contributor. Someone's wearing that shoe, he's going to be sweating, shedding. One other contributor. He was the minor. On the most intimate of the objects, he was the minor contributor. So, remember, Mr. Guinea, Mr. Sanders had a girlfriend, Shadaria Cody, Mr. Guinea had a girlfriend supposedly at Appleyard. Shavers and Wright are the only ones who are together, so naturally their DNA might not be on it. Naturally. Okay, and they never checked for anybody else's DNA. So now I'm going to go to the other evidence that I think proves very strongly that Mr. Wright was not involved in this. The text messages, the phones. Yes, Mr. Wright did not have a phone. Nothing nefarious about that. You saw, remember all those text messages we saw Mr. Corbett go over after the shooting, after Officer Babb was shot. We had all these text messages around various people. Yet supposedly Mr. Sanders, supposedly texting Ms. Cody, some other people, supposedly Mr. Guinea, everyone's girlfriend. This is what I've heard the testimony of. The only testimony that could be even close remotely to Mr. Wright was supposedly, I believe it was Mr. Guinea, was contacting Destiny Evans, Mr. Wright's girlfriend. Okay. Now, Mr. Guinea would not be contacting Destiny, Mr. Wright's girlfriend, to say, hey, has Mr. Wright, has John Darius called you? Where is he? Everybody knows that John Darius can't call anyone. If he's running away, he's the one who doesn't have a phone. No, you don't call Ms. Evans to say, hey, what's going on? Do you know where Wright is? You don't do that. That makes no sense. But you do call Destiny if you know Mr. Wright or believe Mr. Wright is with her. That makes perfect sense. That's the only reason that Destiny would be contacted. No other reason. Now, maybe they will claim, maybe the government might claim on rebuttal. I won't get a chance to stand up here again and speak again and say that, no, he was just trying to find out if she heard from him, if she knew what was going on. That would be speculation. There's no evidence of that. And the inference I'm drawing, or the belief that what I think it shows quite clearly, and it makes sense, is just as strong as a lot of the other government's beliefs about what the evidence says concerning Mr. Wright. Can't have it both ways. It's clear Mr. Wright was not present. Somebody's in his car. You might be dealing with someone who's angry. You know, a lot of these others were just text. This was a long conversation on one of them. I think he said 54 minutes on Facebook. No, that's not a, hey, is he there with you? That's, he's there maybe, but that doesn't make Mr. Wright guilty. In fact, it shows he's innocent. There's no surveillance footage showing them coming back. There's no surveillance footage showing them leaving, I believe, to go, or if it does, you can't see who's driving off to do the crimes. I believe all we saw was them going up to the storage unit, but I think it doesn't matter because we don't see them returning, which is very important. The slides. We heard government saying, when he's arrested, he's wearing slides. So, white athletic shoes are very common. There's nothing uncommon about that. And I saw no evidence about a search warrant or what was recovered out of any motel room. It's like Mr. Shavers. They thought they had someone, they didn't look anymore. It's like the DNA. They have someone, they don't look anymore. What else is in there? So I'm not going to belabor the fact that the slides or the sandals or whatever they're called now doesn't mean anything. So there is none of the other video returning. I've already spoke to you about Mr. Corbett's identifications and how those don't really matter anywhere. He has the records are good, yes. And doesn't matter that his phone was there. Anyone could be using it. Give me a moment. I apologize. I'm almost done. This is a circumstantial evidence case. And circumstantial evidence is built upon a chain of inferences or conclusions. You all are educated people. You know what I'm speaking about. Yes. And circumstantial evidence can be powerful, but when circumstantial evidence can point in two different directions, one guilty and one not guilty, then your job as a juror is not guilty. And if the circumstantial evidence points in two different directions, that breaks that chain that sometimes prosecutors like to talk about. Breaks the chain completely. Doesn't damage the chain, smashes it. That's all we have here. Now, I'm not going to ask you to look at your papers. You're going to have this back there with your jury instructions. I know that was a lot to go through. It was a lot. There was a lot to get them together. But on page 28, and it's very important, it's the reasonable doubt instruction. And that's the bedrock of our criminal law. That's the way we've always been in this country. We don't take chances in convicting someone. And it's right there in the law. And you don't have to read along. You'll have it back there. And y'all can go ahead and please look at it when you're back there. But I know everyone keeps telling you to go read. And there's going to be two other people talking after I sit down. So I'm just going to tell you what I think is important about it. If after carefully considering, comparing, and weighing all the evidence, as it applies to Mr. Wright, there is not an abiding conviction of guilt. Abiding. That's a very important word. Strong. It's not numerical. This is not math. This is not artificial intelligence. Thank God. This is a human endeavor. And that's why there are multiple of you to bring all your wisdom and judgment together to discuss it. And that's what actually comes to a more accurate conclusion than filling stuff into a computer. But if you don't have an abiding conviction of guilt, or if you think, yeah, I have a conviction or a belief that he's guilty, but it's one that's not stable, it wavers or it vacillates, if you ever not, certain, it's not guilty. And a reasonable doubt comes from the evidence, conflict in the evidence, or lack of evidence. Conflict in the evidence, circumstantial, inferences that can be drawn in different directions. That's conflict in the evidence. And that's a not guilty verdict for Mr. Wright. I have nothing else to say. I hope I didn't forget anything. I'm getting kept sit down. I don't get a chance to speak again. This is it. So I want to thank you once again. That is sincere on behalf of everyone. And I'm going to sit down and I'm going to ask that when you go back and deliberate, please consider carefully everything I've said and the evidence when you make your decision. And I believe if you do so, based on the law and the evidence, it'll be not guilty. And that's what I'm going to ask you to find Mr. Wright on all counts. So thank you very much.
That's good, because you just heard a lot of information, and unfortunately I have a lot more that I have to go over with you. Thank you so much for all the attention you've been paying to this. Usually when people are drafted into being on jury duty, they don't have 3 co-defendant trials. So it's a lot quicker. It's not a whole week. So we really understand how much effort you guys are putting into it, and thank you. So the state's argument is not that Mr. Guinea actually went inside to either of these locations to attempt to rob or kill anyone. The state's argument is that Mr. Guinea helped out Mr. Wright by driving them away from the scene at Cypress, that Mr. Wright knew what was going on, helped plan the robbery, shooting at Sandpiper by agreeing to be that getaway driver. With that being said, most of my argument will be focused on 2 areas. One is the element of accessory for charges 4, and the second will be the elements of principle for Mr. Guinea's remaining charges, which would be 5, 6, and 7. I will touch on the robberies and shootings themselves briefly, but I know the other co-defendants' counsel has talked about those, so I'm not going to belabor any points. With Mr. Guinea, it is really simple. Did the state have enough evidence to prove that just based on his text messages during and after the incidents, and the fact that he was around people alleged to have committed crimes, does that make him guilty by association with them? No. The answer is no. The state made many assumptions of what things meant and dismissed other bits of evidence as not relevant if it didn't fit that narrative. Honestly, this is not surprising because this is a very emotionally charged case. 2 people were shot and injured that night pretty coldly for no real reason at all. It was ruthless what happened that night. But does Mr. Guinea being there, aka in a car, make him guilty? The only way it would is if you believe that he actually knew what the plan was and helped devise that plan. So let's talk about that. I want to start at Cypress Point because that's the first incident of the night. They have cell phone data and or surveillance putting Mr. Guinea, Mr. Sanders, and Mr. Wright, presumably, together at the Baymont, and then leaving the Baymont to go to a storage unit of some sort on September 24, 2023 for Mario Chambers. So far, there's nothing criminal here. There's nothing wrong with what they did, going to a storage unit, opening it for someone else. There's nothing wrong with that. They seem to return back to the Baymont Hotel, where Mr. Guinea texts outside to Mr. Chambers, and we'd imagine perhaps that Mr. Chambers comes down, collects whatever it is that they obtained from his storage unit. We would guess. Who knows? Because there's not any surveillance footage shown, even though it supposedly is running continuously and is motion activated. Mr. Chambers coming out of this motel room actually would have been captured because there was a surveillance footage camera right in the middle of that hallway. I'm not sure how that was missed. Again, regardless of that, nothing here, whatever happened or not, is criminal at this point. Then it appears they head off to Appleyard Drive in the area of Mr. Guinea's girlfriend's place. They leave around midnight, and from the cell phone tower data, you can see Mr. Guinea leaves with him, and it is inconclusive if Mr. Sanders does or not, or Mr. Wright leaves with him. Again, nothing here is criminal. Defense would submit that when you're seeing Mr. Guinea's location move down toward the Cypress location, that is while he is a passenger in Mr. Wright's Corolla. After all, Mr. Wright was the one who was driving it when they left the Baymont. There is zero evidence that Mr. Guinea would drive Mr. Wright's Corolla. Anything to that point would be an assumption. And when it comes to criminal cases, assumption after assumption leads directly into reasonable doubt, which is a not guilty verdict. As you see from surveillance at the gas station across from the Cypress house, that a Corolla drives by at 12:40 a.m. You not see how far away it parks from that residence or anything of that sort. Most importantly, you don't even see a driver. You don't see how many people are in the car. You do see, if you look very closely, as the state pointed out, and know where to look, that there is some light coming from maybe the muzzle going off, a gunfire around 12:46 a.m., right by the back entrance of that house. When it comes to Mr. Wright and his charge inside the house, I'm going to say that you would have to look to the evidence there presented by the state to see what you think on what happened inside that house. I'd suggest you look at that first, since if you find him not guilty, then Mr. Guinea would automatically be not guilty since there wasn't a crime to be an accessory to at Cypress. But if you do find that a crime occurred, then you would move on to Mr. Guinea and consider the evidence. As for Mr. Guinea, I think it's perfectly clear he was never alleged to have been inside. No one from inside that house reported more than one person entering it. Therefore, where is Mr. Guinea other than the car? How far is the car from the location? Is it within some sort of walking distance? You can't see when someone comes into the screen and goes into the yard, into the house, to know how far back they were. You see nothing of that to make any educated guesses on where that car is parked. So is it likely that Mr. Guinea was in the car and did not hear shots? Yes, that's likely, probable, and even possible. It's even reasonable. And how do we know that? No one else in that neighborhood called 911 that night to report that shots were fired. At Sandpiper, we have a different story. So there's a good chance it wasn't loud enough for even Mr. Guinea to hear it. Another thing could have been Mr. Guinea sitting in the car. If the car's running, perhaps the radio's on. We cannot assume one way or the other. We cannot see Mr. Wright, if that is who the person who went inside was, come running out. Therefore, you can't reasonably say with any type of certainty that he ran or walked back towards the vehicle. You do, however, see a Corolla leaving at 12:46 a.m. You again do not see who is driving that Corolla. This is all the hard fact evidence that you have before you when it comes to Cypress that included any of Mr. Guinea's alleged involvements. Nothing more, nothing less. Being outside in the car while something is taking place is not a crime. Being in the car with someone after they committed a crime is also not a crime. Being in proximity is not a crime or proof that he knew the crime was being committed or that it was committed. If that was proof, you'd see an instruction that proximity is enough to infer that, but you don't. In order to get Mr. Guinea as an accessory to this, the state would have to prove 4 elements, which is on page 17. There's so many pages you guys are looking at. So for Mr. Guinea's purposes, that would be page 17. I'm going to focus on elements 2 and 4, which have to do with him directly and not Mr. Wright's alleged actions inside that house. I want to be very clear that even if you think that Mr. Wright is guilty of what occurred inside of Cypress, that is only element 1 for the accessory after the fact. There's still elements 2 through 4. So let's talk about elements 2 and 4 specifically because they're semi-similar. Element 2 is after the attempted murder and or burglary was committed, Mr. Guinea maintained, assisted, aided, or attempted to aid John Darius Wright. And element 4, again semi-similar, is that Mr. Guinea did so with the intent that Mr. Wright avoid or escape detection, arrest, trial, or punishment. So that begs us to the question of, did Mr. Guinea attempt for this Cypress incident to help Mr. Wright escaping some form of detection by assisting or attempting to assist him in getting away? Well, you have him and Mr. Guinea in his, Mr. Wright's car. The only proof that you have ever had of who was driving that car was from the Baymont Hotel, and it was not Mr. Guinea. So where is it coming from that Mr. Guinea, all of a sudden at Cypress, is now the driver? Oh, right. All that information is from the state. It's a huge assumption that they're asking you to leap off the ledge to take. Is it not equally reasonable that someone can drive someone, get out, and hop right back in the driver's seat? Do they have to jump in the passenger seat? No. There are no text messages saying this, no admissions from anyone about him driving to or from Cypress. You have no surveillance cameras showing him as the driver.
when they passed by, not even those public safety cameras, which, mind you, Detective Bailey had said were all over Tallahassee, that caught Mr. Guinea later on in a passenger seat of somebody else's vehicle. There is not even evidence before you that he drove that car ever before. However, there is evidence before you that Mr. Wright has driven that car before many times, and then that car is associated with him. So if we are playing a game of what is more likely, it wouldn't be Mr. Guinea, the one with no driver's license, driving away from a scene of a crime. Regardless, what is more likely is still not the standard you are held to today. So if the state's theory is Mr. Guinea aided him by helping him escape that night by driving away, that is a huge leap that they're asking you to make, and it must be rejected by you because there's no evidence to support this theory. Maybe they will switch it to saying, okay, well, if he wasn't driving, well, he helped him in some other way not get detected. How? How did he aid him in this crime? Was he supposed to be the lookout? Sitting in the passenger seat as he texted back and forth with his girlfriend about hanging out with another man? If that's the case, he's taking it just oh so seriously. If you are to believe that this is the theory, that Mr. Guinea could have known about it beforehand and aided as a lookout for that 5 or so minutes they sat there before Mr. Wright even enters, he's not even paying attention to Mr. Wright. He's texting on his phone. You have the text messages. Look at those messages. If Mr. Wright is supposedly telling him his alleged plan of going inside and doing whatever, is Mr. Guinea like, yeah, cool, I'll keep the lookout, as he's texting his girlfriend back? Especially as he sits in the passenger seat. I mean, what is he to do if he looks up from his phone and sees something or someone? Call Mr. Wright? On what cell phone? Mr. Wright doesn't have a cell phone. What is he aiding him with? There is nothing entered into evidence that would prove that Mr. Guinea knew about anything that was about to go on in that house. Again, it makes zero sense, and that it would take another assumption that they must have talked about it, which there is no proof, which is why it's called an assumption. How does he know to be the getaway driver to something he wasn't even privy to? If he wasn't told about it, let's say. How does he know that he needed to be the getaway driver? So let's see, what is the last theory the state could have on this of aiding? If he wasn't the driver nor the lookout, because he didn't know beforehand, let's say, was he let in on it once Mr. Wright got back into the car? Well, let's look at the evidence here. There's no text messages to anybody saying anything about what just happened with Mr. Wright at Cypress, nor is there any WCTV searches for Mr. Guinea's phone right afterwards or even an hour later, which the state obviously thinks implicates somebody in a crime. So what can tell you all that Mr. Guinea was told by Mr. Wright about what happened in that house? Nothing. Just another assumption that because they were in the car together, afterwards, he would have had to let Mr. Guinea in on what was going on. And let's say he did. Where's the crime? Do you see anywhere in your jury instructions where it said it's a crime to just simply know that a crime was committed and nothing more? Of course it's not. Because you would need more than that. You would need to actually know that Mr. Guinea knew and that he helped in some capacity. This brings me to element 3 of accessory. Mr. Guinea had to know that Mr. Wright committed a crime in order for this whole principle thing to work out. And as I was just saying, it would be a leap of faith you'd have to take. And there is no room for that in a criminal trial. There is only beyond a reasonable doubt. Not, oh, well, they were in the same car, he must have told them. Or, well, Mr. Guinea must have asked because it probably looks suspicious. Did it? You wouldn't know without making assumptions that is not supported anywhere in the evidence. This is not how it works. It is not a probably, it is not a maybe, it is not an assumption, it's not a more than likely, it is a he did this beyond a reasonable doubt. I get that it is very easy to try to fill in the blanks. And I think of how something could have happened that night. But you have to have evidence to back that up when it comes to a verdict. You cannot make a verdict against Mr. Guinea based on what you think about Mr. Wright or Mr. Sanders either. This must be based solely on evidence against Mr. Guinea and him alone as an individual, and your jury instructions will explain that. When you are back there, ask yourself this, or even write it down. When looking at the elements against Mr. Guinea, ask yourself, is what I am considering a fact that has been entered into evidence, or is an assumption from the state's theory? Which one is it? Because even if it fits something for another co-defendant, it must be taken separately to each charge and each defendant here. So one more little recap about Cypress going through those elements together. Element 1, the crime occurred and was committed by co-defendant Wright. That's completely dependent on your verdict when it comes to Mr. Wright to decide whether that element is specifically met or not. Element 2, Mr. Guinea maintained, assisted, aided, or attempted to aid Mr. Wright. How? If you think he is the driver, that is an assumption not supported by any evidence that is before you. If you think he was the lookout, that is an assumption. If you think he knew and helped him escape, again, how if you have to make an assumption on who was driving that night? You have nothing but assumptions when it even comes to making that element work. Element 3, Mr. Guinea knew that Mr. Wright committed that crime. Again, nothing but mere speculation, a more than likely comments and assumptions. That is well below the burden that you are held to in order to convict any of these defendants. Element 4, Mr. Guinea intended to help Mr. Wright avoid detection or escape. How would he have done that? Where is the proof of that? I am not asking for you to make leaps of faith here, unlike the state. I am asking you to follow the law and only convict Mr. Guinea if you actually have evidence, not assumptions or more than likelies, in front of you to support each of these elements. For Cypress, there is nothing but that. The just verdict is not guilty, regardless of how many times you think something could be more than likely, because that's just not the standard. Now I want to move our attention to Sandpiper. I'd imagine that this is the one that gets a little more confusing regarding Mr. Guinea. When it comes to Sandpiper, Mr. Guinea is charged with counts 5, 6, and 7. I would encourage you, because this probably would make the most logical sense, to start with Cypress for Mr. Wright, and then you can move on to Mr. Guinea, and then when you bring your attention to Sandpiper, by focusing on Mr. Wright and Mr. Sanders first. I say that because the principal theory for Mr. Guinea only comes into play if you believe that the crimes actually did happen at Sandpiper, and that Mr. Wright and or Mr. Sanders committed or attempted to commit those. Makes sense. If you find that a crime was committed by one or both of them, of the co-defendants, then you can move on to if you think Mr. Guinea was involved as this getaway driver in this crime. Remember that the state's theory may be the same for both Cypress and Sandpiper regarding Mr. Guinea, but they are in fact separate charges and incidences. That means there is a chance you could come back on a different verdict as to Mr. Guinea to both. It doesn't have to be the same. However, the defense would submit it to not guilty as to both. The state will say they think principal this time because he stayed after Cypress, but again, it seemed like they went straight from, it seemed like he wasn't driving, and they went straight from one location to another. When was he supposed to abandon this if he knew about it? But I'll leave that to your guys' judgment. For the Sandpiper incident, the state has to prove the following two elements for all three counts that have to do with Mr. Guinea, and that's on page 26, so you can mark that down. Element 1, Mr. Guinea intended the crime to occur, and element 2, Mr. Guinea did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other persons to actually commit or to attempt to commit a crime. And these charges, I'm sure the state is feeling more comfortable since there are texts that they have pointed out, not just cell tower data that they think could help convict Mr. Guinea here. However, that is because they gave those texts their own spin, their own interpretation to them in order to fit their theory of the case. The hard evidence you have before you that is pretty set in stone is the following. They show cell site data showing Mr. Guinea and Mr. Sanders together, presumably with Mr. Wright, who doesn't have a cell phone, around Sandpiper an hour or so in a semi-stationary position. That would mean they're either sitting in a car or they're walking around somewhere very close by in a neighborhood. You do have before you some surveillance before the incident that shows the Corolla going by, and then the same direction 20 minutes later, 3 individuals going by. 2 can be identified with their clothing as Mr. Wright, Mr. Sanders, at least if you take those image comparisons from the Baymont. The other one is dressed in red, has not been on camera before that, so he remains unidentified. There has been no ID made. Potentially it could be Chavers. You have the Corolla leaving when body-worn camera puts the cops just getting there. They match that with Mr. Guinnea's cell phone leaving at the very same time, right before anyone came outside of Sandpiper, and Officer Babb got shot. They also made image comparisons of Mr. Sanders and Mr. Wright coming out of that house to the earlier Baymont footage. When they came out, they were running in different directions, Mr. Sanders and Mr. Wright. Finding the last hard piece of evidence is that they have cell phone data of Mr. Guinea driving around for a few hours afterwards and answering some calls between Sanders and Mr. Wright's girlfriend, Destiny Eves. Nothing that I just listed out convicts Mr. Guinea on its own, unless at some point the state has removed every single reasonable doubt and has convinced you that not only had Mr. Guinea just intended this crime to occur, but he said or did something that actually helped them commit this crime. Remember, that second element says that he had to do some act or say something that was intended to and did incite, cause, encourage, or assist in the committing or attempt to commit that crime, being the burglary or the attempted homicide. That means you need something more than just what I listed off as evidence in front of you. You need something else. You need his text messages that showed admission, or something that says this is the plan, or proof that Mr. Guinea did not just intend but did pick up Mr. Wright and or Mr. Sanders to help them with this crime, which we know he did not because that's not even the state's theory. It sounds like to me maybe the state's theory is he tried to be the getaway driver, left his post when the going got tough, heard sirens, changed his mind, stayed in the area for a few hours and tried to pick him up but just couldn't. Is that enough even if he found it to be true? What act did he do that was intended to help and actually did help them? There is no evidence before you that he drove Mr. Wright and Mr. Sanders or anyone else to that crime scene. None. There is evidence that he drove away from it, at least evidence that you can make a reasonable inference from. His arriving there driving is a huge leap of an assumption that they make. Again, same argument as before. Why would he be driving a car not associated with him? Even better, why would they have him drive a car knowing if they got pulled over, they were driving around with a guy who didn't have a driver's license? That would definitely be high risk. The whole point of having a getaway driver is to actually get away. It's in the name. Moreover, if Mr. Guinea was the getaway driver and that was the plan, why are there no texts or calls to him when the 911 call was made to hurry up and drive by the place and pick me up? That 911 call was 7 minutes long. You can hear people talking throughout the call, according to the state. They even realize she is on a call at some point. Why wouldn't they call him? Why aren't there messages to Mr. Guinea's phone right around then? If Mr. Sanders was able to call within minutes of running, why not the same be true when things started to go down before they walked out of the house? Why not have him sitting there on speed dial to come back up the street if that was his entire job that night? If Mr. Guinea was planned to be the getaway driver who parked down the street to avoid detection, would Mr. Sanders and Mr. Wright run in opposite directions? If they weren't going to call him when they were done, then the plan must have been that they would have needed to run back to the vehicle where it was left. Why would they run in opposite directions? Mr. Sanders nowhere in the direction of the car, in the opposite direction. An equal explanation to this, opposite of him being a getaway driver, is that he was just with them at the wrong place at the wrong time, and that's not a crime. Him being there and then leaving when he heard sirens is not a crime. Now, if he did stay in that area to help them escape and then actually did it, we could talk about an actual crime. But we all know that both of those things did not happen. Is there even enough evidence to suggest not only that he stayed in that area, but he did so intending to help them? No. Now we are getting back into assumption land where the state has spun their interpretations on all these text messages and cell phone tower data because they obviously need something more to prove this, or else we wouldn't need this whole PowerPoint. That's why they spend so much time on it, because they need something. They need to tie him better. So it's time to address those texts and put an alternate theory, because that is all the state or any of us can do, since there are zero admissions, zero, saying that he wanted this to happen and helped it happen. Just a message that he wanted to make sure they were safe. Again, still not enough. The PowerPoint starts off with text to his girlfriend T, saying he was going to be trying to put some together, and then clarifies with her that something he's trying to put together is some money. This is at 10:30 p.m. before the incidences happen. Obviously, it would be great for the state, great for them, to spin this, to say that this must be about him, Mr. Sanders, Mr. Wright, devising this big plan to go rob and shoot some people. This would be great for the state. And again, without something more, an assumption is being made. The something more on another theory, defense's theory, suggests that Mr. Guinea was trying to put together some drug buys to make some money that night. He is a drug dealer. He doesn't say we are trying to put something together, so we can't assume he even met a group. He just says trying to put something together. It was also a text to her, to his girlfriend, not to Mr. Sanders, not to Mr. Sanders saying, hey man, let's put something together, stop by the Baymont, let's talk about it. There's no messages of that. Defense would submit that Mr. Guinea must have seen her, T, his girlfriend, after this at some point, maybe when they show his location going back to Appleyard before the Cypress incident. Why do I say this? Because the next set of text messages you have sound like they're in the middle of a fight. Not that they just started, but that they're in the middle of one. So obviously he came back and talked to her. They're in the middle of a fight. Who knows what they talked about during that time frame? I'm not going to make any assumptions. But later on at 2:33 a.m., he asks her, he sends a text, WYD, what are you doing? She responds, apparently knowing there was some intention behind that specific question, because her response is, she ain't text me back. As if they already had a conversation about something at the house. She ain't text me back. And then minutes later, she says, without him responding to that first message, she's still hanging, you got gas money? He replies, yes. Well, what could gas money and her still hanging out possibly mean? We know that gas is slang for weed. We know that Mr. Corbett admitted to it on the stand as a prior law enforcement agent for over 30 years, even on a piece of the evidence. Matter of fact, I'll show it to you. In it states Exhibit 87, you can see some of the weed that was taken from the other house, not successfully, in its package. And it says gas house, because that's what weed can be referred to all. How else do you know that Mr. Guinea must have been making some cheese, as he later puts it? Well, during the midst of him supposedly so worried about his boys being out there by themselves and needing to pick them up, he makes stops. This girl T was talking about, as she says in the next text messages when you look at them, that girl that she was talking to wasn't going to be home anytime soon. So he reaches out to another contact named Summer. And they end up meeting up at 3:49 a.m. in the morning. Whether they meet up at a gas station is unknown, because come to pump one could have been more slang for what type or how much. It literally could have been a meetup spot where he pulled into a specific pump to sell weed at. Who knows? If he was traveling around Tallahassee that night in specific areas, which, by the way, is also where he stays in those areas, in his own neighborhoods, and making some stops, we at least know that some of his stops had to do with drugs, had to do with buying gas, pull up to pump one, all of these references to weed. What planned out getaway driver, a planned out devised plan for him to be a getaway driver, is seriously sitting here, not dropping his location for Mr. Sanders to run to, or asking for an updated address, but asking these girls or other people, let's meet up, let's link up and do XYZ. Remember, Mr. Sanders didn't even run in the right direction of where he should have known the car to be. So already off to a bad start with the state's theory that he knew Mr. Guinea was the getaway driver, right? Because if he knew that, he would have ran in that direction and maybe could have escaped if Mr. Guinea was an actual getaway driver. Then there's calls and texts his location, Mr. Sanders, with zero follow-up or giddy up from Mr. Guinea. Instead, he immediately asks, almost at the exact same time he's asking Mr. Guinea, Miss Cody, for the same type of help. If he had a designated getaway driver, why would he feel the need to immediately, within the same 30 seconds, text his girlfriend, help me, with a location? Could it be that he knew Mr. Guinea wasn't going to go and help him? Mr. Guinea was upset and didn't want to be involved in whatever the heck this was? Obviously, zero faith in Mr. Guinea coming in and helping him if he's texting somebody else within the same 30 seconds. And guess what? She makes more attempts than Mr. Guinea does. That is literal evidence in front of you. She tries to go and pick him up. She sends her location. Mr. Guinea doesn't do that. She says she is 2 minutes away. Mr. Guinea doesn't do that. She then says the police have her surrounded. She can't get by. Mr. Guinea doesn't say any of that. He's riding around the rest of Tallahassee selling drugs, doing whatever he wants to do. They even show her in the area, just like Mr. Guinea was. She testifies she even called his family for him because she couldn't get him in time, because she was actually trying to pick him up. Ask yourself, did Mr. Guinea do all of that? Do you have any proof of him doing that? Or is the only proof that you have a FaceTime call where you don't know what was said? Again, you don't know what type of conversation they had. You don't know if it went on this polar side of, I don't want to be involved in whatever the heck you guys have going on, or I'm not going to pick you up, or whatever it was. You have no idea. Again, an assumption. That's what you have. A FaceTime call and a drop location. An assumption from the state that that must mean the whole time Mr. Guinea, he was supposed to pick him up. That's what his job was. With Miss Cody there were no assumptions. And for some reason, she's not sitting over here at defense table. A choice. That was made by the state attorney's office. Mr. Guinea also could not have known what was going on that night, just like Miss Cody didn't at first. He could have assumed something bad happened since sirens were coming this direction while sitting in the car waiting for what he thought could have been a drug deal or something like that, none of his business, and chose to get out of there. Now, I know the state is saying, oh, but if Mr. Guinea goes and sells drugs, why would Mr. Sanders and them need to go and get drugs from someone else? Maybe it was a different type of drug. Maybe he didn't have as much as they needed. Who's to say? Being caught up in a neighborhood at that time of night with the car running, not living there with weed on you, not a good look. So he bounced. Is there anything that points to him not knowing it was happening? Yes. Him hearing sirens, and instead of taking Parrot Road to Falcon Crest, him driving off of Sandpiper to get to Falcon Crest, to get off of the neighborhood, literally putting himself dead smack in front of the house that the incident is taking place in. The state is going to say, well, it was a corner property. They're duplexes. It wasn't the one right there that was a corner property. It was the one next to it. Not necessarily your typical corner lot property. Another reason you could say he may not have known is that there's so much evidence saying that as they're saying that there's much evidence saying that as there is the opposite, which is just assumptions. He's looking up WCTV coverage continuously. Perhaps that explanation is to figure out what happened. Did they get arrested? Because they keep calling me. What's going on? Is that a crime? Is it a crime to look up WCTV nowadays? If you hear sirens, is that a crime? When he realized how serious it was, he could have started calling the guy's family members, just like Miss Cody did, who's not charged. The state pointed out how he was on a call with Destiny Evans, Wright's girlfriend, for a while. And then he texted Summer he was on the phone with his people around 4 something in the morning. Again, is that a crime? Is it a crime? Miss Cody did it. When he ends up talking to police about it, he lies about his whereabouts. Sure does. Just like Miss Cody did the first time she talked to police. She explained on the stand, something that we probably all could assume and know, but that not everybody's comfortable talking to the police. And there are some neighborhoods and areas that grow up knowing and being taught not to talk to the police. They're not there to help you. So don't be honest with them. Don't trust them. They grew up in the same parts of Tallahassee. Why isn't Mr. Guinea given the same grace? That is because the state makes huge leaps with assumptions that Mr. Guinea must have known and purchased him in this plane. He just must have. How? Sadly for them, there is no actual direct proof. Being somewhere where a crime is occurring and then getting spooked and leaving after either just witnessing or hearing something and not knowing, not a crime. Not even an attempt at something. The state will then point you to him also answering and sending or attempting to call Mr. Sanders later that night. Okay. I'm sure he was calling many people. Mr. Sanders was probably calling many people when his phone was working. We know it wasn't just Mr. Guinea he was calling. How does that unilaterally tie Mr. Guinea into knowing and devising this plan and acting as a getaway driver? The state in their PowerPoint then turns to, well, he changed his number and he sent some text afterwards that sounded like he was involved because he is in hiding for it. More assumptions without any investigations done into them. Just taken at their word.
Right.
Did they look into how often Mr. Guinea would change his number before this? No. I suspect if they would have, they could have found out, just like Mr. Corbett had agreed with me, that drug dealers change their phone numbers quite often. Could that not be an equally plausible reason for him changing his number? Did Mr. Guinea leave Tallahassee? No. You saw on October 2nd, a week or so later, he was still in the same neighborhoods in Tallahassee when he got pulled over. He even planned on going to work the very next day after this happened, but T, his girlfriend, was way too scared for him. Him saying to her that he was in the clear could also equally be interpreted as, I wasn't involved, so I'm good. You don't know the languages and the slangs that people understand and interpret. Again, different interpretations. If he was involved with the shooting of a Tallahassee cop that is all over the news, why would he ever think it was a good idea to just go back to work and not go straight into hiding if he even thought they suspected him to be involved? But eventually, you can assume that anyone who knew who he hung out with that night probably advised him it doesn't look good for you. Just like T did. Worried. So then you get days later text messages of him saying how he was going to do just that. Peer pressure and anxiety can get anyone to start acting in ways that look suspicious, even when they're innocent. I mean, who at this point, or at that point, is going to believe him when he didn't know that that was the plan? The police? The police were going to believe him? After one of their own just got shot? Really? Not when their job stops at probable cause. But your job does not stop there. And that's why we're here. Mr. Guinea is making a statement by sitting over there at counsel table. That statement is that he's not guilty. It is not up to you to make assumptions about what happened that night. An assumption is not circumstantial or direct evidence. It is simply an interpretation of what the state wants you to believe to fit their narrative. And they have a job to do. I mean, one man was shot straight in the face, and another was shot at, and a cop who was just doing his job to protect his community was shot and almost died on scene from his injuries. They even tried to suggest at some point, the state did, that Mr. Guinea switched cars. And they literally had zero proof of that. I asked, zero proof. Think about that. They're trying to tie up all these loose ends, such as why wasn't the car recovered with Guinea? Who was it recovered with? Interesting. They probably would have loved to tie him in to that. But they couldn't. So another assumption, he must have switched cars in the middle of the night. No proof of it, but he must have. And of course they want to wrap this up with a little bow. But the issue is not really with the state, it's with the cops in this investigation because they stopped short. They assumed guilty by association when cutting those warrants. They assumed and must have known and helped in some way. And technically, they can do just that. Because when they're making an arrest, it's at a very, very low standard. It's at probable cause, as low as you can go. Unfortunately for the state, a conviction takes much, much more than that. So if it was so important, right, those text messages to tie him in, supposedly guilty and a part of this plan, the cops would have needed to do a better, more thorough investigation for that. They should have called T. They should have called Summer, two people by his phone records that he was sure to have met up with that very night. They could have asked them, just like they did Miss Cody and others, if they knew of Mr. Guinea being involved in this, was there any admissions? Did he say anything to you? That would have been great evidence for the state, right? But they didn't. They didn't investigate that. When they saw text messages days later that sound like they could have led to an incriminating statement, such as the messages between Licia when he says he will call her and not text about it, they should have tracked her down and asked what that phone call was about. That would have gave you some great evidence, right? And mind you, the answer from her could have easily been that he didn't want to incriminate or speculate about what he heard from others about what happened, not about him even being involved at all. There's always another side to the token. And mind you, they didn't do that. They didn't go and investigate any of these people that he had direct connection with, saying things that they're now saying, oh, this is it. This text right here, this proves everything. If it proves everything, why don't you back it up by the person who it was sent to? But you didn't. You didn't even try. Guilty by association. Didn't need it. Probable cause. So again, I will ask when you are back there to ask yourself, is there really any hard evidence of fact that's entered into the record regarding Mr. Guinea's involvement here, or are there just assumptions made to get you there? As your jury instructions say, a reasonable doubt can come from three places: the evidence, lack of the evidence, and conflicts in the evidence. When it comes to Mr. Guinea, there's so much that was stopped short in the investigation that too many assumptions had to be made regarding his involvement. Too many. This is lack of evidence. On page 28 of your jury instructions, it talks about reasonable doubt. I believe one of the other defense attorneys mentioned page 28. It's an important page. As I said during jury selection, and like it says there in your jury instructions, quote, if you have a reasonable doubt, you must return a verdict of not guilty. Now the state gets a chance to come back up here, and they hold the entire burden, not us. So that is why they get the last word, okay? I suspect that they will say I was ragging on them this entire time by them putting a spin on all these messages and everything like that, all these web searches, yet they're going to say I did the same thing, right? I gave a different interpretation of it. Yes, that was on purpose. That was the entire point of what I'm trying to make. Because if you are back there looking at a piece of evidence, such as location, texts, calls, surveillance, and you think there is one reasonable interpretation that could lead to guilty, but then you're also seeing one reasonable interpretation that could lead to not guilty, guess what that is? A reasonable doubt. It doesn't matter if there are 10 reasonable interpretations that the state is bringing up leading to guilty on one of these counts. If there is one reasonable interpretation leading to not guilty, then the just verdict on that count is not guilty. And that's why I give that example in jury selection. But just to be clear, I'm not coming up with that. Again, if you have a reasonable doubt, you should find the defendant not guilty. If you have zero reasonable doubt, you should find the defendant guilty. Moreover, there is a reason that I wanted you all to separate what is an evidence and facts introduced at trial versus what is actually just the state's spin, interpretation, and assumptions. So right on page 28, it says, quote, "It is to the evidence introduced in this trial and to it alone that you are to look to for proof." To the evidence entered in. What we, the lawyers, say is not evidence. It is simply our take on something, and you all individually and jointly have to sit down and come to a decision on whether or not jumps are being made, or if it is plainly right there in evidence, in black and white, proving his guilt or innocence. If it is not plainly there one way or another, that should also give you an answer. Keep in mind that the conversations about Mr. Guinea is completely separate from whether or not you think the state proved guilt of the other two co-defendants. It is not a one and done. They are separately charged but tried together for ease. My job is to just point out things for your conversation involving Mr. Guinea, specifically my client. Once you take away all the assumptions thrown at you by the state's interpretation of this evidence, you are left with massive amounts of reasonable doubts. There may be reasonable doubts that you picked up on that I haven't even said, and that's fine. September 25th, 2023 was a horrific day for multiple families. They do deserve justice. However, justice is not convicting a man on assumptions, especially not an innocent one. Mr. Guinea walked in here an innocent man. I'm now asking you to allow him to walk out the same. He's not guilty of these charges. Thank you.
Thank you, Ms. Phelps Hernandez. Rebuttal argument, Ms. Kappelman, whenever you're ready.
Good afternoon, ladies and gentlemen. And you're going to get a couple more thank yous from me. As Mr. Lemon said, I know we've been thanking you all, and we appreciate you all being here, and that is the absolute truth. Because essentially, ladies and gentlemen, all we could ever do is ask for a fair trial. And remember, I represent Mr. Raheem Sanders. And since the trial began, we've been seeing everybody taking their notes and being in tune and paying attention. And that is something that we really do appreciate. And I know I appreciate it. And again, I know Mr. Sanders appreciates it as well. And, in my opening, I said this case was going to be difficult, primarily because there's, again, three defendants, three lawyers up here talking, and a ton of evidence, and trying to keep it all compartmentalized as to, does this apply to this particular person? Does this apply? Does this one apply? This one does not apply, so on and so forth. And ladies and gentlemen, this is really what cases are about. The state has their belief, like I said, in jury selection. We have our belief. We have our theory of the case. That's what, in the legal terms, it's called a theory of the case. But really, what it really is what we believe happened. And in this case, this is what we know happened. And I asked you all in jury selection as well that we were going to be asking you to come back for a not guilty verdict for Mr. Sanders. And that's what I'm going, in opening, I said I was going to ask you for a not guilty verdict for Mr. Sanders, and I'm going to be asking for a not guilty verdict here again today. Because we believe that the state has not met its burden beyond a reasonable doubt for counts 5, 6, and 7 for Mr. Sanders. So essentially, what have we learned in this case differently than what I told you in the opening? Right? What has been different? In the opening, I told you, I said, you're going to hear testimony and evidence that Mr. Sanders was dropped off at the Baymont. That's true. That is what happened. He was dropped off at the Baymont. There's no dispute in there whatsoever. Now, we're not going to get here and try to tell you that it was some mystery person. No, Mr. Sanders was dropped off at the Baymont. I also indicated that once they left the Baymont, Mr. Sanders went to another one of his girlfriend's house, and I think there's been some evidence and testimony indicating that, there was, he has a girlfriend and some one girl that he was seeing when he came up here from Gainesville. So there is nothing inconsistent about that. What we do have, though, is where the state may try to say, oh, well, that's not quite right, because the address where Mr. Sanders stops communicating, his cell phone stops communicating, is near Mr. Guinea's address. Well, here's the thing, what we talked about with Mr. Corbett, Investigator Corbett. The 770 Appleyard Drive, it's not like GPS. It is not like, it's not GPS. It is not accurate within feet of where we are. If you have a GPS, it's going to tell you exactly where you are. The cell phone towers, and when I was using the term pinging, and he said it's mostly acceptable, but it's used as communication. It's like cell phone towers communicating here, there. But Mr. Sanders' phone, Mr. Corbett, Investigator Corbett, said that his phone would work via Wi-Fi or the data carrier, right? So clearly we know that this phone is and can be moving, and if it's moving about, it's going to be picking up. I mean, there's got to be some tower somewhere. The carrier is not just going to not send a signal, but for Mr. Sanders, it stops right there. And so there has not been any evidence or testimony to dispute that Mr. Sanders was not at one of his lady friends' house. And that's where he was, ladies and gentlemen. Now, the fact that it just so happens to be where Mr. Guinea may live, but again, Investigator Corbett did say that there's a lot, and I don't exactly recall exactly what the terminology was. He may have said it was a lot of residences over there, or plenty, or some version of that. And that they were free, they're freestanding. So there's no evidence to contradict that. And the reason why there's no evidence to contradict that, because that's where Mr. Sanders was. That's why his cell phone was not moving anymore, And as far as what we know, Ms. Kappelman indicated that, Mr. Sanders wasn't present at the 4681, so he wasn't charged. That's right. He shouldn't have been charged because he wasn't there. He was where his phone last showed him at. So absolutely he shouldn't be charged there. Now, what we said in the opening, again, has been consistent. There's been nothing different about that. We said that Mr. Sanders' phone, 770, close by there, and then it picks up again over at the Sandpiper address. You know why it picks up over at the Sandpiper address? Because he was over there by the Sandpiper address. That is exactly right. We said that is, again, that's not in dispute here. But what was he over there for? That may be what's in dispute. What was he over there for? Ladies and gentlemen, he was over there because he was thinking that there was going to be just a purchase of some marijuana, and that was going to be it. And just like we said in jury selection, things changed at, I don't know if I said a drop of a dime or a snap of a finger, one of them, but things changed immediately when he got there. There is no evidence against Mr. Sanders that says that he was planning a robbery, he wanted to participate in a robbery, he wanted to get a lick, he wanted to get cheese. No, what he wanted to do was go over there, purchase his weed, and leave. That's what he wanted to do. That's what was happening. At least that's what he thought was happening until things changed so quickly. Now, we also talked about it in jury selection as well, that, I think Ms. Kappelman was saying, people don't do this, people don't do that if they're innocent. Well, we talked about it in jury selection too, that, hey, just because you run, that does not mean that you're guilty. That doesn't mean that you're guilty. I mean, again, if you're there for one particular reason and something else goes extremely wrong, as it did here, what are you going to do? Do you stay or do you go? And again, Mr. Sanders in this particular incident took the fight or flight and said, hey, I'm going to flee, right? He flees from there. So we said that. Again, there's nothing different. It has not been disputed, anything about that. I also said in the opening that you were going to see some text messages, which you did. And I said those text messages were going to say, help me. You're going to see, you saw those text messages, you'll get a chance to see them again. And the one thing that is, I won't use the term funny about text messages, but there's always a reason why people with text messages and emails, they always say, hey, when you're angry and you're about to send an email or text message, rethink it, bring it back, because you can't really tell the tone of a text message or an email. And in this particular case, Mr. Sanders' text messages were of the help me version. And if you had to probably interpret that, that probably means he was excited, something bad just happened, help me, help me. There was no other text messages from anybody else saying, help me. Mr. Sanders was asking for help because something bad had happened that he was not expecting to happen. One of the things about over at the Sandpiper address, Miss Cody, she got up and she testified. Whether you get to judge her testimony, however that's for you all to judge. But this shooting over at Sandpiper did not have any. It wasn't Mr. Sanders that did any shooting. I think that is pretty darn clear from all of the evidence and testimony that we've heard. I think that is absolutely clear that Mr. Sanders did not shoot. I think you'll be able to see the videos. You can watch them over and over, and you're going to see that Mr. Sanders did not have a firearm. He did not shoot a firearm. You're going to see him just run away. And Miss Cody, who's known Mr. Sanders for, at this point in time, I think about 3, maybe a little more than 3 months. She's known his family. One of the things I asked her was this. I said, had you ever seen Mr. Sanders with a firearm? She goes, no, I haven't seen him. I don't have him with a firearm. Now, what does that mean? Does that mean he's never had a firearm? Does that mean he couldn't even go get a firearm? No, it doesn't mean that, because he could, right? He could do that, but he didn't do that. And the video evidence shows that he did not have a firearm. And that's what's important here. He didn't have a firearm. One of the things I got a little bit of pushback on from Ms. Kappelman was we talked about, I said that in the opening, that Mr. Sanders went home immediately, I may have said immediately, almost immediately after this entire incident took place. Well, again, Investigator Corbett, we talked about that too. Immediate is relative. I mean, he stayed here for 2 days and went home because that was what happened with him. He went home. But that does not show anything that he is guilty of the crime over at Sandpiper. Now, what I want to talk to you all about a little bit is some of the witnesses and why Mr. Sanders is not guilty. Mr. Sanders, as I said, he's charged with count 5, burglary of a dwelling with a person assaulted. And this is only at the Sandpiper's location. And that the first witness that you heard from was Miss Oglesby. And no doubt, there's absolutely no doubt that a bad event and a traumatic event took place. And we can't undercut that. Something bad and traumatic did happen. But Ms. Oglesby, I don't know if she actually knew which person may have had a firearm. At one point, she said she didn't know if it was one person. Then she said she didn't know. Then she said, I think it was 2 people or not. It was dark in the house. Montreal Harris says that the house was dark. He says that they had been drinking and smoking a lot. So what she actually saw, what she actually thought she saw, we don't really know, because whether she was under the influence, whether it was bad lighting, or whether she just didn't know at all. But one of the things about that is Ms. Oglesby says that she was taken out of the bathroom at gunpoint, a gun pointed at her. And I guess she, you know, she's trying to maybe say that this was Mr. Sanders, which I would tell you that it's not Mr. Sanders, because one of the things about this is that if Miss Oglesby was taken out of the bathroom at gunpoint, right? We do not hear any type of screaming from Miss Oglesby from being drugged out of the bathroom at gunpoint. Now, that's not to say that she wouldn't scream, but ladies and gentlemen, people often scream if they walk in their bathroom and they see like a spider or a bug or something, they're gonna just scream. The fact that you could be drugged out of your bathroom at gunpoint and not make a single sound, you know, that is somewhat, you know, unbelievable. The other part of this too is that she says that she's been taken out of the bathroom at gunpoint and that we don't hear the perpetrator, telling her to get out of the bathroom or making any type of aggressive remarks or any ruffling in the bathroom that is trying to take her out. The likelihood of somebody taking somebody out of the bathroom at gunpoint, they're going to say something. And we know that we could hear what was going on because the 911 call, you could hear the 911 callers in the back because they're still getting calls and you can hear that. But you don't hear anybody saying, you know, get out of here, you know, put the phone down, things that would just kind of make sense if you're being taken out of the bathroom at gunpoint. So you don't hear that. So I would just say for Ms. Oglesby, you know, again, her testimony is her testimony, and you get to evaluate that testimony. But I'll tell you, ladies and gentlemen, the facts don't add up that she was taken out of the bathroom at gunpoint. And she also does not know if it was one person or two people with a gun. I'm telling you, it was just one person. And the one person was not Mr. Sanders. One of the other reasons why we know it wasn't Mr. Sanders is because of Officer Babb. We know it wasn't Mr. Sanders who had a firearm. Officer Babb told you that he was giving chase, and I asked him on cross-examination, did you see the person with the gun? No, I didn't see the person with a gun. Did the person turn back towards you with a gun? No, I did not. The person didn't do any of that. So the person that fled was Mr. Sanders. So he flees and he doesn't have a firearm. So it would be absolutely amazing if Mr. Sanders could have a firearm in the house and immediately come upon Officer Babb, and somehow or another this firearm just miraculously disappears. It didn't happen because he didn't have a firearm. He was out there, just like I said in the opening, he was out there waiting on a weed transaction to be completed, and things just kind of went to the left after that. They didn't find a second firearm inside of the house. The other thing that they didn't find either was any type of, you know, we've talked about DNA. There was no fingerprints. There's no DNA. There's no physical evidence of Mr. Sanders ever being inside of the house. The only thing that you see about Mr. Sanders is what you can watch on the video where he is fleeing and running from Officer Babb. That's what you see. And he's running because he knows something bad has just happened that he wasn't involved with, nor was he expecting. Also, no firearm for Mr. Sanders there because I forget which FDLE agent talked about the caliber of casings that were found in the projectiles. But what she said was this. She said that there were only 9mm casings, 9mm projectiles, and 40 caliber casings, and I believe 40 caliber projectiles. Now, what that means is, yeah, there could have been multiple 9mm firearms used because they were, and you saw that. But what she said that was important was that these particular casings are all TPD casings. All the cases were TPD. And then you had the 40 caliber, which tells us this, that there was no third firearm involved and no third firearm that would have been in the possession of Mr. Sanders. And again, he didn't have a firearm. As well as, what is my new? Lauren McLean. She is the witness that lived or lives, I don't know if she still lives there or not, but lives on Marriott Road, if I'm pronouncing that correctly. She encountered Mr. Sanders hiding behind her car, right? Everybody remembers that testimony. And no doubt she's out walking her dog. It's 3 in the morning, dog is sick. She runs across a male, hunched down by her vehicle. And what does he say? He says, please don't call the cops. Now, that is very important because if he had a firearm, if he was involved in this, in this burglary, I doubt that he would be so nice. I mean, please don't call the cops. That's not what a person who does a violent act does. It's not going to ask anybody please on anything. But he asked this lady, please don't call the cops. And then what does he do in a very short period of time? He says, please don't call the cops. They make eye contact for, I think she said maybe 5 or 10 seconds. I don't recall. If you have it in your notes, you can check back. And then he gets up and he runs away. That's what he does. He's still trying to get away. Now, count 5 with what Mr. Sanders has been charged with, the state, there's no burglary. There's no burglary of a dwelling by Mr. Sanders. There's no burglary of a dwelling there. And the state has not met its burden as far as for even proving. This case is about evidence and what has been presented. And there's been no evidence presented that Mr. Sanders committed a burglary. Now, I will say, I'm gonna take that back just a little bit, because we do have Officer Babb who says that he saw a suspect exiting the apartment. He does say that, the Sandpiper apartment. And I do agree with Ms. Kappelman and what the state has said. It is, a miracle and by the grace of God that he survived, that he still has his leg, even more so that he is actually even working again. And I think everybody here can appreciate all of that. But my job, I have to represent Mr. Sanders. And so one of the things that I had to look at again and over was, how did Officer Babb see Mr. Sanders exiting the apartment at Sandpiper? Because the only video evidence that we have shows Mr. Sanders out by the fence upon approach, and then he's running away. And based off of the angles that you look at, and when you get back there, take a look at it, it almost looks as if it would be difficult for Officer Babb to see Mr. Sanders exit the apartment the way that it's set up with the fencing, and from the encounter that he had where Mr. Sanders was actually located. So I think you just have to take a look at it and come draw your own conclusion with it. But from the way that it is set up, ladies and gentlemen, Mr. Sanders was already outside of the apartment where I said he was, waiting for this transaction to be completed. He never entered the apartment. He was already there. He was already where he was, which at that particular location, there is where the cars are parked at. So you'll just have to take a look at it and see. And one of the other things about it is, again, Officer Babb, testimony was fine, but those things are kind of left to question for us because, you know, they have on all of this equipment. He talked about the earpiece, they have walkie-talkies, they have everything. He was given pursuit of Mr. Sanders initially. He was given pursuit of Mr. Sanders. And I guess if he would have seen Mr. Sanders exit the target apartment, that means that he, you know, he would have been, I guess we can use the term a high value target if he saw him exit the apartment. But Officer Babb says that he went back because he saw someone exit the apartment with a firearm. And I guess in the reasonable person thinking and just kind of me using my common sense on this, it looks to us and appears to us that the reason why Officer Babb would have abandoned his, you know, chase of Mr. Sanders is because Mr. Sanders didn't pose a real threat. He didn't have a firearm. Officer Babb has testified that he didn't see him with a firearm. He was already out, and he went back to go see the real threat that was coming out of the door. That seems more likely as to what happened. You know, and again, I asked Officer Babb about, you know, can you call, you know, can you let your colleagues know that you're in pursuit? He said that, you know, I guess he may have not had time to do that, but, you know, whether timing was an issue or not, he did abandon the chase. And it seems more likely that the abandonment of that chase was because Mr. Sanders did not have a firearm, did not pose a real threat. And the real threat was actually coming from out of the house, which we actually saw was a real, true, and violent threat as a result of that. So when we talk about that part of it, when we get to count 6, attempted felony murder with a firearm, again, there is no firearm to place with Mr. Sanders. There's been no evidence of a firearm that Mr. Sanders has a firearm. And the best person that would have been able to see if he had a firearm would have been Officer Babb, who told you that he didn't see a firearm. The person didn't turn with him against him with a firearm. Now, count 7, attempted felony murder of a law enforcement officer with a firearm against Officer Babb. Really, for the same logic that I just said, I think if we just common sense wise would say this guy is running away from something that he had no idea was about to happen, did not plan it, did not anticipate any of this, was not expecting gunshots to ring out, was not expecting an officer to be shot, didn't have a firearm, didn't have a gun, didn't have any of that, didn't do any of these things, then clearly there can be no attempted felony murder of Officer Babb with a firearm. So where does that leave us at as far as for evidence? Not a lot. There's not a lot. And what I'm telling you now is essentially, I believe, what you all have heard and what I've said briefly in my opening. But there's not a lot. And let's talk about what is the physical evidence. I've gone through each count, and there is no physical evidence. There is no physical evidence that says that Mr. Sanders over here committed these crimes. All we know is that he was there. And we talked about that at jury selection. I hope everybody still remembers that when we were talking about just because you're merely present at a scene where a crime happens, that does not mean that you either did the crime or you participated in the crime. And I think everybody here kind of agreed with that. Just because you're there doesn't mean that you actually did it. And I think the evidence supports that. The evidence, or lack of evidence in this case, supports that. Yes, he's there, but he doesn't have any of the tools or anything that would make him guilty, or the state has proved beyond a reasonable doubt that he committed any of these crimes. Not at all. So when we're talking about the actual physical evidence, there is none because there is no firearm. Nobody places him with a firearm for certain. Absolutely not. Because you can't go by Ms. Oglesby because she said, I think, I don't remember, maybe, maybe not, I don't remember. So that in itself is reasonable doubt, even on her part, that Mr. Sanders did not have a firearm. And then we go to, get my, Maria Hyatt, the FDLE DNA expert. What did she say about Mr. Sanders? You know, DNA is DNA. DNA has gotten a lot of people convicted, but it also has gotten a lot of people out of trouble as well. And it is the standard. It is now the gold standard for criminal law. But what did she say about Mr. Sanders' DNA? DNA, he was excluded, not inconclusive, excluded, meaning he was not there. They have no traces of him being there. Also, there are no fingerprints there. And if he would have entered the apartment, I mean, there's no mention about anything about any fingerprints being there. And that unit was processed. The unit was processed. They didn't come back with any DNA for Mr. Sanders. They didn't come back with any fingerprints for Mr. Sanders. So there's no physical evidence there that he was ever inside the apartment. And you know why? Because he was not inside the apartment. He was right there where he was when you can see it on the video. Now, ladies and gentlemen, again, your job here is to kind of make sense of all the evidence that has been presented. There's been a ton of evidence that has been presented, but none of it, really applies to Mr. Sanders. I would ask you all to think about the things that I said. As you know, what I'm telling you is not evidence. The evidence and lack of evidence is what you've heard thus far. But when we take it all and we put it all together, there is no evidence that Mr. Sanders, committed any of these offenses. None at all. Whether it's there's no cell phone messages. We asked Mr. Corbett, and I keep calling Mr. Corbett, which is Mr. Investigator Corbett. I asked him, was there any text messages from Mr. Sanders to anybody else about planning and participating in this? There is none. There is no DNA. There are no fingerprints of Mr. Sanders. There's no firearm of Mr. Sanders. Mr. Sanders is not even, the state can't even say he discharged the firearm because there is no firearm. Ladies and gentlemen,
I know you've had enough, and I'm sorry. But I'm going to address some of those. I know you've had enough. You don't want to hear one more lawyer talk person? Come on. What's one more? Okay, I want to start with Mr. Guinea's closing. Guinea did not go into either place. Agreed. Based on the text messages and the location information, can we say he's guilty by association? Absolutely not. Guilty by association isn't a thing. We know that. It's got to be evidence. Only you guys can decide. I went through every piece of evidence that I think shows he's guilty. They've got an explanation for every single piece of it. You have to make a decision. What is compelling to you, and when do coincidences and bad luck add up to basically not a coincidence anymore, right? I mean, a couple bad things can happen to you. A couple things could get taken out of context, maybe, but at some point, it's going to be evidence of the crime, right? So I guess you guys are going to look at those things individually and make a decision whether, I've got it all wrong and I'm twisting everything and making assumptions about everything, or whether, it's what it appears to be. And it's not that gas doesn't mean gas, and nothing is what it appears to be, and nothing means what it says. It's, I mean, at some point, it's like just what it appears to be is what it is. Okay. So that's my big takeaway on Guinea's closing. It does not matter what I think. If you think I twisted things or made assumptions about things, you look at it. You decide what it means, right? You decide what it means. Zero evidence. Guinea drove the Corolla, and then later, but Guinea did drive the Corolla out of the scene. So I think we got an admission that Guinea drove the Corolla, and that is the evidence. That is what I'm saying makes him an accessory to the first one and a principal to the second one. He drove the getaway car. Why did he leave in the getaway car? Why did he try to help? They said, oh, well, trying to help doesn't do it. He had to actually pick him up to be a principal. That's not true. Page 17, to be an accessory. After the attempted murder or burglary was committed, Tyrell Guinea maintained, assisted, aided, or attempted to aid John Darius Wright. He didn't pick him up, but he tried. And that is what makes him an accessory to the first one and a principal to the second one. Guinea is making a statement by sitting over there. No, he made a statement, and his statement was that he was in Orlando. That was his statement. He didn't choose not to talk to the police because he didn't trust or didn't like the police. He chose to give a whole story about Universal Studios in Orlando. But I guess you should just let him slide on that too, because that's probably what an innocent person would do. All right, let's go to Sanders. Sanders. He could have been at a neighboring residence instead of at Guinea's place on Appleyard. Who cares? That's not where the crime occurred. Where was he when the crime occurred? That's what we care about. We couldn't put him at the first one, so we didn't charge him with the first one. We put him dead to rights at the second one, and that's why he's charged with the second one. Why do we care whether he was at a girlfriend's house or at Guinea's house? He was over there near where they were, and then he went to Sandpiper. What we care about is that he entered Sandpiper. What we care about is that he was armed when he went in there. What we care about is that he put his gun in the face of the young lady in there. That's what we care about. That's what he's charged with. We care about him running from Babb and putting Babb in danger while his buddy jumped out and shot Officer Babb. No evidence Sanders was planning armed robbery. He didn't text about it. Well, who cares? He did the armed robbery. I mean, we care about planning and knowledge and all that when we're trying to press charges against the driver, but this guy actually went in there with a gun. He's guilty of the armed robbery at Sandpiper. We don't care how much planning you do if you're the guy that goes in there and points the gun at people. What else? Oh, we misinterpreted his text messages too. Again, you look at it, you decide. I mean, there's a text in there. We just shared Nigga. I mean, look at that text. You tell me. It's the luckiest typo of his life, if you ask the state. What else on Sanders? Oh, he must not have had a gun because he didn't shoot at Officer Babb. Rest assured that TPD chases subjects all over this city every night that have guns. They don't all shoot at the officers, thank God.
So it's argument, members of the jury, remember what the lawyer says, not proof or evidence or your instruction on the law. You may proceed, Ms. Kaplan.
The evidence has shown that this defendant, Wright over here, has a itchy trigger finger. He is quick on the trigger. He shot without hesitation at Cypress Point. He shot without hesitation at Sandpiper inside that residence with those people. And when confronted by law enforcement, he didn't hesitate for a moment to shoot Officer Babb, a uniformed officer. That doesn't mean that Sanders didn't have a gun on his person when he fled. Oh, well, Miss Oglesby didn't scream. She must be lying about being a victim of a robbery. All little girls that are victims of robbery scream. No, her defense mechanism was to get quiet as a mouse. You could hardly hear her on the 911 tape half the time. You can hear the subjects in the background. Listen to it again. I mean, they're not screaming right into the phone, but you hear them observe her and make her come out of there. And then you can't hear anything really anymore because she's out of the bathroom now. What motive would Miss Oglesby, she's a school teacher in Tampa, have to come here and lie to you about some bearded guy that robbed her 3 years ago? She doesn't have one. I don't think she stuttered when she said the thick subject with the full beard and the black hoodie pointed a gun in her face. And then they stand up here and say there was no evidence. No evidence that my client went into the house. No evidence that my client did an armed robbery. It's like, that was evidence. What motive does she have to lie? Let's talk about Wright's closing argument. Well, Mario Shavers should be charged. Oh, Chandrea Cody should be charged. Okay, maybe they should be. How does that make your client less guilty? The phone stayed at Baymont and the cops drew the conclusion that he wasn't there. Okay. Okay, that's not what Corbett said. He said that an analysis was done on the events of Mr. Shavers' phone, as well as a review of the Baymont surveillance video, all of which was used to make a determination that there was not sufficient evidence to charge Shavers. I don't know. Why would Wright be somewhere that somebody was getting their hair braided? I don't know. He's friends with the hair braiding lady. Who cares? The point is, Ms. Cody had an opportunity to see him before. She had an opportunity to see him that night, and she recognized him, and she identified him. And is it really the defense that that's not right on the Baymont video? Surely not. Obviously, Shavers is the connection to Cypress Point. What? There's no evidence of that. Because he's got a connection to the ones at Cypress, he must be the connection to the first one. No evidence of that. I mean, to the contrary, Mr. Patel, I know what I was going to say. The argument that they had to know where they were going when they went into the Patel residence, and I'm saying they, but it was just Mr. Wright. Wright knew where he was going. It's like, well, no, he didn't. He went into the only evidence we have is Mr. Patel, the dad, said that he had pocket money. I thought it was $500,000, but it ended up being $500 to $1,000 in pocket money. So the money, presumably, the only money we know about in the house was the dad Patel's, not the son Patel. So arguably they were in the wrong room. I don't know where we get that he knew where he was going. I mean, he did go right in there and shoot somebody, but I don't know that he knew the right place to go to look for the money. What else? The Patel ID is bad. Okay, but he picked the one out of the three that was the shooter, that all the other evidence points to as the shooter. So I guess he just got lucky when he randomly picked somebody out of the arrestees to identify as the shooter. He picked the one that is tied to the gun, the shoe, the DNA. Pretty much everything in the case points directly to him. This case is not based solely on eyewitness identification in reference to Mr. Wright, okay? We have an eyewitness identification, but we have a lot of other things too, all of which the defense is telling you is no good. What else? The DNA. It's not compelling because it's a mixture. Well, maybe that would be a good argument if he had been on one item. You know, we've got a mixture, we've got all of these clothing, and, you know, Wright is on the shoe, but he's the minor donor and he's not on anything else. He's on every piece of evidence. Every piece. Oh, man, he is really unlucky. Boy, he's doing laundry with the wrong people, isn't he? If he's not the perpetrator, how unlucky for him. There's no definitive conclusions in the DNA. Really? The results on some of those items was higher than the highest statistic that FDLE reports, because they cap it, right? at more than 700 billion. It would take more than 100 times the population of the Earth to create a likelihood that you could find somebody else. I think that's pretty definitive.
Jury will rely on its own memory of the evidence. You may proceed, Ms. Kaplan.
Pretty definitive. In closing, Wright is dead to rights as the shooter. I don't know how you can go back there and find anything else, but he could not and did not do it alone. He did not act alone. The evidence has shown that. The conduct of all these men was so dangerous. The evidence is there and they must be held accountable for their roles. They didn't all do the same thing. That's why they're not all charged in exactly the same way. But they all made choices, right, that brought them to this point. It's not bad luck. It's not coincidence. It's not some vindictive prosecution who's, targeting innocent people. It is a tragic episode. You are bound to convict for the highest offense that has been proven beyond a reasonable doubt. When you get back there, please do not compromise your verdict, okay? Render a verdict that speaks the truth in this case. And that is a verdict of guilty as charged. Thank you.
Thank you, Ms. Kaplan. One last. All right, submitting the case to the jury, page 33. In just a few moments, you'll be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until the juror verdict. You must not talk about the case in person, through the telephone, writing, electronic communication, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you. If you become aware of any violation of these instructions or any other instruction I've given in this case, you must tell me by giving a note to the bailiff. Many of you may have had cell phones, tablets, laptops, other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices with the deputy, who will safeguard your devices while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. Continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries and more, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. You may at this time retire to deliberate your verdict. 2, 3. Thank you, Joey.
Judge, did you need to speak to the?
Yes, just for a second. Thanks. Jury doors closed. Any matters that we need to attend to at this moment? No, sir. I'll just ask if the lawyers review the evidence before we send it back to the jury. Let me know if there's any dispute. So I just wanted to thank you for following through your service. I know you didn't ask for this responsibility. Sometimes I feel like the alternates are disappointed. Sometimes I feel.
And now it is time for the verdict. Thanks for watching Deep Dive True Crime, and I will see you all in the next one.
Are you serious?